when I told him here it was nothing specific on it, what I was talking about on it. I didn't want anything in here to be any way attorney-client privilege or to identify what I was talking to my client about on it. So I tried to keep it basically as neutral as I could. At this point in time, man, I didn't know how much had happened. I believed the AG's office, when they tell someone to do something, I had no idea the extent of what they did on it. I was hopeful that they actually didn't read the mail like they said. I was hopeful that the sheriff only listened to a couple seconds. And so I was trying to give Brad information he would need to have to do the investigation on it. Every conversation I have with my client is super important on it. And so when you look at the previous exhibit, I never did anything underhanded. I tried to always identify myself.
So I'm told that I need to be nice and I shouldn't interrupt, but I feel like I need to interrupt you at this point. Let's just go through. So would you agree with me that what you're telling Brad at that time, when you were being interviewed by Brad, at the end of 2024, is that you're telling Brad that after the mail incident on March 7, 2023, you tried to protect your client's attorney-client privilege rights when you were with him, right?
I did.
Yeah, and in doing so, after March 7, 2023, you talked in generalities, correct?
I'll agree that says exactly what it says.
And you operated as if somebody was listening, is that right?
That's what this says.
And so, really, the communication involved, I'm not saying you wouldn't be prejudiced if some of the other information was leaked out to the prosecution. You know, the communications after March 7th. I'm not saying you wouldn't be prejudiced, but when we're looking at the window of prejudice, you would agree that happens from the very first call about February 14th to about March 7th. That's when you're acting like that and nobody's listening, you're talking strategy, you're talking to your client about those things, right?
No.
Well, you just said that after March 7th, you only talked generalities and you operated at people listening. We're listening.
I acted like that, but I was under the belief that it had been cured. I had no idea until Brad completed his investigation how bad it was. But I did extra insurances of saying when they called my cell phone to make sure to say, this is Lance Jasper, your attorney. But I'm not going to tell Brad the content, the stuff about what I'm saying, or to direct you to the points where important calls are made on it. I don't trust you, Dan. And so I'm trying to do my best to insulate my client on it.
So I guess I just want to be clear here, that whether you're standing by your testimony to Brad or not. And this is the question. Did you operate as if the state of Montana, the person you don't trust, Dan Kaczynski, Brad Tucker, was listening to those calls after March 7th?
I took extra steps to insulate, to make sure that everybody knew that I was an attorney when I was talking on the phone. And I still had to talk to my client. I'm not going to disclose what I discussed with my client, but I had to speak to him. Every time I talk to my client, it's down the board and it shouldn't be listened to.
Right, and you keep this, I feel like this is such a critical issue, and I don't want to get the court mad at me for keep going on about it, but I just want to be clear here. You operated as if I was listening, right? That's what you said a moment ago.
I did, because I said the attorney, yes.
You, at some point, Brad Tucker gave you a form, is that right?
Yes.
And That was in November 29, 2023. Brad Tucker gave you a form, right?
He emailed me a form.
And he asked you to fill it out, right?
His email speaks for itself, yes. It says, please see below on it, and it says, ask me to sign it, yes.
And you didn't want to sign it, right?
Absolutely not.
And you did not want to provide your number, Jordan Kilby's number, your office number in that form, did you?
No, my client was out of jail at that point.
Right. But he asked you to do it, right?
He did.
And you weren't aware that you would be protecting your client's rights, so those numbers would be locked at that point so people couldn't go back?
No.
There's an argument in it.
You know that? And then,
Hold on a second, did you have an answer, Mr. Jasper?
Yes. No, because there was no explanation, and the only thing I could see about it was it looked like something that would be put into a file to make it look like there was some form that it looked like I didn't fill out. Followed up by the email response that I gave to him.
but regardless of Mr. Tucker's asking you to fill it out, the judge just 2 weeks earlier, on November 16, 2023, ordered you to provide the Dawson County Sheriff's Office with the numbers of your firm, ordered you to provide the state with the numbers of your firm, ordered you to provide the Dawson County Correctional Facility with the numbers of your firm. You are obligated to do what Brad Tucker asked you to do, right?
I am not aware of that, but it certainly didn't mention that he was asking me pursuant to an order. All I saw was a form, and that was by the detention officer below it. If it would have explained, hey, this is pursuant to something, I would have done it, but all of you guys know my numbers on it, and so.
But I want to talk to you about that. Do you think Dan Kaczynski is untrustworthy, as you said he is, and wants to be responsible for making sure the detention center gets the exact numbers that you call, if phone calls change? Don't you think that should be your responsibility and not my responsibility? Or Mike G, it's pronounced G, is responsibility. You think it should be ours?
If you don't think I provided our number and stuff to this detention center with all of the stuff we've done, you just aren't going to convince you on it. So.
Well, let me ask you a question. Document 60 here is an order by Judge Rager.
I haven't seen it, so I'd have to look at it.
Should be
Sure.
in the binder.
What's
Put it in his binder.
No, it's not. Let me show it to defense counsel. It's document 60 in the pleadings, if you guys have access to that, but I can show it to you. Would you like to see document?
I would.
This is document 60. I'm going to mark it as State Exhibit 28, Your Honor. And I don't know if there's objections. I would move for its admission. It's already in the file, but it's,
No objection. Exhibit 28, document 60 in the court file. Yes.
are you reviewing that document?
I am. I'm looking also to that person with other information.
I just wanted to look at that document if you could. And if you want, you can skip to the last paragraph. It might be easier. what you recall is that Judge Rieger ordered you to do this, and what she ordered you to do specifically in part in this order is, it is further ordered that counsel for the defendant shall provide the state, the Dawson County Sheriff's Office, and detention facility, and the Prairie County Sheriff's Office with the phone numbers they have used or will utilize in communicating with the defendant during his time at the Dawson County Detention Center. And it's dated November 16, 2023, right?
Yes.
And
Can I see that again?
you have a question?
Do you read, this is contingent on him being in detention, not when he's out.
Show me where it's contingent on being in detention.
Sure. It says, it's further ordered that counsel for the defendant shall provide the state, Dawson County Sheriff's Office and the detention facility and the Prairie County Sheriff's Office with the phone numbers they have used or will utilize in communicating with the defendant during his time at the Dawson County Detention Center.
Yeah, I think the word used probably escaped you originally when you read it, but it says numbers that you have used, right?
And we've done that.
You did that?
Absolutely. All of you have that, those numbers. Yeah.
It says you shall provide. This is afterwards. So when after November 16th did you ever provide a list of numbers to the state, to Dawson County, to Prairie County, to DCCF?
They have all our numbers.
That's not what the judge ordered you to do. You raised an issue. The judge ordered you to provide those numbers to those facilities. Are you saying that you did not comply with those orders? With this
I
order?
don't know.
If you did comply, you would expect to have some sort of notice or email, right?
I can look, I just don't have it here in front of me.
You believe you complied with that November 16th order?
I generally comply with court orders, yes.
But then 2 weeks later, when Brad Tucker asked you to fill out a form, you don't say to Brad in that email, because you do a follow-up email, you know, I already did this pursuant to the order, do you?
I don't know what he's asking for at the time. If he would have explained for it, all it says on it speaks for itself. It just-
It's a form asking you for to register your phone number, right?
He's working for you, Dan.
I'm just asking you, you never stated after he gave you the form that I just provided this to the court, right? You just simply refused to do it.
You saw my response speaks for itself.
Earlier we talked about how you first became aware of the violation of attorney-client privilege with Sheriff Lewis in February 2023, right?
Yeah. And through Mike, I can't remember exactly, Mike being the sheriff, but I meant the sheriff at the courthouse.
You talked to him about it, right?
I did.
And then you also indicated that in March you found out about the letters, right?
Yes.
And then you bring it up to the judge in November, right?
Well, I bring it up before that with you and continue to try to get my client moved through.
We can get through this. I'm asking you when you brought it up to the judge. Was in November, right?
Yes, when I'm at the bond here, trying to get him out is one of the factors.
And then when Brad is talking to you and interviewing you, he asked you a simple question of why you don't simply register your numbers. Do you remember that?
I don't remember that. But it could be, I'm not going to dispute it. He could have.
Well, let's play it then, just to refresh your memory. I'm moving to the introduction of what's been stipulated States Exhibit 25, Your Honor. Excuse me, actually I'm going to start with the first one. States Exhibit 22, which is the recording of several pages in this interview, and States Exhibit 23. This is a longer portion, Your Honor, that provides context to what is being discussed. I would like to be part of the record for the court's consideration, but I don't need to play it today. But if I could just offer States Exhibit 23 and 22 without objection.
I'm going to play it all because I'd like to hear it also, but it's on the record. It's,
Yeah, Judge, I would make a.
Your client's saying something.
I would make a completeness objection. But if what Mr. Gazinski is saying is true is that these are just portions of the interview. The entire interview has been edited, so I don't.
Right, I have the entire interview transcript as EE. Is there a reason that are there concerns that the audio recording is better than the written?
I think listening to the audio is something that the state would want to do. The court, I mean,
So I'm fine with that, but I want the whole thing. I don't want portions. If you want me to listen to the recording in order to have context based on tone, then I would like a copy of the entire transcript. The entire interview, excuse me, in the effort to make sure I have a complete record.
Okay, then if I could, Your Honor, just to save some time, is I would like just to cross off the transcript. We don't have to play it now. I do think that what I'm offering in State's Exhibit 22 and the transcript for this issue, as the court goes through the issue, would make it easier to find. We will provide after this hearing a whole copy of the audio interview, though. So I'd still move for State's Exhibit 20. Last time.
23.
Yes, Your Honor.
So, given Ms. Lyons at the table, then supplement, which I believe would be 29. Is that your last number?
Yes, ma'am.
Okay, so the state will supplement to provide the court with a complete copy of the audio interview by Agent Tucker of Mr. Jasper. That will be marked as Exhibit 29. Do you have an objection to the excerpts that are presented in 22 and 23?
No.
All right, so 22 and 23 are admitted. 29 will be provided to the court and will also be admitted.
And then, if you don't mind going to page 18 of State's Exhibit 6, Defense Exhibit EE, page stamp 2194.
So 2194 and what other number?
It's, right now we're just looking at 2194 State's Exhibit 6 for Defendant's Exhibit E.
And is this an attempt to refresh the recollection of the witness and he's been unable to answer a question? What is the purpose of using the record?
Well, he's an agent for that person over there, so I think I can ask him any question about the statements that he's made.
Right, but generally we don't direct someone to a transcript of the prior recording unless there's an issue with their memory. So would you like to ask Mr. Jasper the question and then if he can't remember, you can direct him to that transcript? I guess I don't understand procedurally why we're going directly to a transcript and have the library sitting there.
Yeah, so I can just ask him about it like directly, officially.
I think that would be great.
I look at it as if he was the defendant sitting here, and I can say to the defendant, I know other witnesses are different, but.
But he's not, he's counsel. And so let's just ask him the question. And if Mr. Jasper can just answer the question, I think we'll get through it much quicker. If there's a memory issue and we need to refresh his recollection, we'll direct him to a portion of the transcript, then we can do that. But I've got two very experienced professional attorneys here, and so I think let's try it the old-fashioned way.
Well, I just think these words, I don't mean to argue with the court, Your Honor, these
But
words.
you are, so let's just keep it. Thanks, Mr.
Okay,
Jasinski.
could you read 2194, the top of the page, please?
Apparently, we're going to disregard the court's order, so go ahead.
Oh, I'm sorry, Your Honor, I'm not trying to do that. Do you have a belief, I'm sorry, do you have a belief?
I think we need time out. I think we need a recess. I think we need to take a break. So we're going to regroup. It's 2:58. We're going to take 20 minutes. The other thing that we have to, I want everyone to start getting our heads around is there is no way this hearing is going to be finished by 5 o'clock today. So start looking at your calendars. I just had some things canceled today to give me some availability. So we're going to have that conversation towards the end of the day. But for now, we're going to take 20 minutes. We'll see everyone at 3:20. Let's regroup and refocus, please. Stay here.
Jason Grey-Eagle, JASONGREYEAGLE.
Thank you, Your Honor. Deputy Gray Eagle, how are you employed?
I'm a deputy with the Prairie County Sheriff's Office.
How long have you been so employed?
Been employed approximately 3 years and 8 months.
Will you please briefly describe your training and background relevant to that employment?
I was on FTO after I got hired, field training and attended the Montana Law Enforcement Academy and graduated with 504 hours of training.
Did you have any military service prior to joining the sheriff's office?
I did, yes.
What was that service?
That was 4 years active duty, and then I was in the National Guard here.
So Deputy Gray Eagle, we're going to cut to the chase. Were you involved in the investigation of Sterling Brown?
I was, yes.
And over the course of that case and your investigation, were you assigned to listen to Mr. Brown's inmate calls?
Yes.
How did you come to be assigned to that task?
In April of 2023, I was injured, and so I was put on night duty and was given that task while on night duty.
When you were given that task, what, if any, direction did you receive?
We were given, or I was given numbers for Mr. Brown's attorneys and told that when those numbers popped up on the call log to not listen to those numbers.
Did you follow that direction?
I did, yes.
Was there ever a time that there was a inadvertent listen or that you did listen to a call with one of
There
those
was
numbers?
this.
When did that happen?
I do not remember a specific date.
It's been a while, that's fair. When that happened, what did you do?
Can I explain how calls went?
Please.
Okay, so when I clicked on the call, the number was not one of the numbers that was listed as an attorney. As soon as, you know, the Mr. Brown had inputted all of his information through the telephone, and when the phone line was answered, it was answered that it was a attorney for Sterling Brown. As soon as I heard that, I immediately ended the call.
What did you do after you ended the call?
I wrote the number down on a Post-it note and gave it to Sheriff Lewis so he had that number to add to the numbers.
And other than that specific call, were there any other calls that you listened to that you understood to be between Mr. Brown and an attorney or the staff for one of his attorneys?
No.
And without telling us what, if anything, you may have heard other than this is his attorney, did you obtain any substantive information from that portion of that call?
I did not.
And have you discussed anything you may have heard during the portion of that call that you listened to with anyone besides here in court today and Agent Tucker when you did an interview with him?
Just Sheriff Lewis when I told him what the number was for.
Okay, I have no further questions. Thank you. I believe the defense may have some for you.
Good afternoon, sir.
Yeah.
Thank you for being here. So, as far as your involvement in the underlying investigation, is it my understanding that you were at the scene of the fire the night it was called in?
Yes, sir.
And then you did investigatory efforts since that time?
Yes, sir.
Collected evidence, interviewed witnesses, did whatever you were directed to do?
Yes, sir.
All as part of the investigation into the events of that night?
Yes, sir.
And then after Mr. Brown and the co-defendant were charged, your investigation was part of that criminal prosecution, correct?
What do you mean, sir?
Just that the work you were doing, you understood to be part of the cases that were being built against those two defendants?
Yes, sir.
Okay. You were directed by Sheriff Lewis to listen to those phone calls, correct?
Yes, sir.
And you understood that that monitoring of the phone calls was part of the investigation, correct?
Yes, sir.
And what you were listening for was any potentially useful or potentially incriminating information, correct?
Yes, sir.
And you discharged that duty.
Yes, sir.
And Sheriff Lewis told you before you began that there were some numbers that you were not supposed to listen to, right?
Yes, sir.
And do you recall how many different numbers he told you were on the attorney list that you should not listen to?
I do not remember, sir. Those were wrote down.
Do you recall there being multiple numbers for Mr. Brown's attorney?
Yes, sir.
Okay. And did you ever yourself listen to any calls from those numbers you were given by Sheriff Lewis?
No, sir.
And you understood that the reason you were to avoid those phone numbers is because they're attorney numbers and you may have attorney-client information being conveyed.
Yes, sir.
And you understood the importance of not accessing that information on purpose, correct?
Yes, sir.
Okay. And did Sheriff Lewis tell you how he came to learn about at least one of those numbers being an attorney number?
He did not.
Did he tell you that he himself had contacted DCCF along with the prosecution team to alert them to those attorney numbers? Did he tell you anything about that?
No, sir.
And then while you're listening to a call from a different number, that's when you heard a message that, or some information that led you to believe it was an attorney-client phone call, right?
Yes, sir.
So there's an Exhibit X that's in evidence. And for just convenience sake and moving along, Your Honor, may I approach with just a highlighted copy given the deputy? So this is Exhibit X, date of call August 1st, 2023, phone number 406-370-3431. And so do you see at the bottom where there's some highlighted language there?
Yes, sir.
And I'll just represent to you that this is a transcript of a phone call that's been redacted except for some very limited information. And can you read the highlighted language there from that particular exhibit there at the bottom?
Yes, sir. You want me to read it out loud?
Yes, sir.
Hey, Sterling and Plans, how are you doing? This is Sterling's attorney. This should not be recorded as this attorney-client privilege.
Is that the language you heard or something similar to it to the best of your memory?
Yes, sir.
And as soon as you heard that language, you knew this is an attorney-client phone call?
Yes, sir.
Did you have any doubt about that?
No, sir.
Did you have any doubt about what you should do in that moment?
No, sir.
And you stopped the call.
Yes, sir.
You alerted Sheriff Lewis.
Yes, sir.
And then Sheriff Lewis testified here that he then alerted DCCF again of an attorney-client issue, gave them that phone number, and also alerted the prosecution team. Is that consistent with your understanding?
I cannot say what Sheriff Lewis did after he gave the numbers, sir.
Your role was alerting Sheriff Lewis of the number, right?
Yes, sir.
Was it your understanding that he then took care of it so it would not happen again?
Yes, sir.
If there was another call listened to a couple of days later from the same cell phone number by someone at DCCF, do you have any explanation of why that would have happened?
No, sir. I cannot say what they did, what they didn't.
And just for the sake of the record, defense exhibit. Pass again, ma'am. Sorry. And Nancy.
Yes.
Okay. You gave a statement to Agent Tucker,
Yes,
and you knew it was recorded,
yes, sir.
and I believe this is a stipulated exhibit. Okay. So for the record, we'll just put this in as exhibit NN. And I have no further questions.
Okay, perfect. And you read directly to the state?
No, thank you, Your Honor. I would ask that Deputy Ray Eagle be released from his subpoenas plural.
Any objection?
No objection, Your Honor. Thank you.
All right, thank you so much.
You in a way that the judge thinks appropriate and is following the rules that we go by.
I don't want to just hear Mr. Jasper read from his own transcript for the next hour and a half. I think what's going to help, remember, the question is back to answer, and that is one on the Brady issue. Were they aware they were turning my call? And two, was any of that information then shared with the team that could have infiltrated the investigation?
I think the only reason I would even take that approach, Your Honor, is to highlight to the court this parts that I want the court to pay attention to. And I can just represent base stamps of the 4 or 5 things I have that I'd like the court to pay attention to. You're gonna have the audio, and then you also will have a transcript. And if I could do that, I could just save a lot of time.
I don't want to hamstring your presentation at all. It's your case that you're presenting, Mr. Kuzinski. My concern is just, it got a little spicy.
I'm sorry.
No, that's okay. There's a lot of emotion. Attorneys, we are very high functioning usually. And we take our reputations and we take our ethics very seriously. And so obviously this is a subject where both sides are going to feel very passionate about it. And that's what I saw was both sides being very passionate about the position. I just want to make sure we get through the evidence. And so if you think that the most expedient way of getting through the evidence is to direct Mr. Jasper to parts of that transcript, then let's do it. But I just want to make sure that we do it in a way that eliminates as much emotion as possible and gets me the facts that I need. So you present your case the way you would like to, but I will stop you if it gets too spicy.
It won't, Your Honor. And thank you. And I just have a few things I'd like to highlight with you, Mr. Jasper. If you could grab State's Exhibit 6, and then also its Defense Exhibit EE, please. That's the recorded interview.
You have those, Mr. Jasper? So the defense exhibits, unfortunately, are not taken by your tabs. State's exhibit as well.
I have my statements.
Oh, you don't have it up there?
No, I have it.
Oh, thank you. I'd like to go to page 17, if you don't mind.
Okay.
I'd like you to look at this base stamp also 2193 up towards the top where Brad Tucker asked you the following, and I'll ask you what your response was. Brad Tucker says, MK, but you, let me ask you this. What direct knowledge do you have that any one particular person provided information from those documents to anybody involved in this investigation? Do you see that question?
I do.
And what was your answer?
That's what it says. That is going to be great for cross-examination.
Thank you. I'd like to go to page 18, page stamp 2194, please.
Okay.
And the question is a long question, but about halfway through Brad Tucker's question, at the top of page 2194, do you see the word did on the first line?
Yes.
And he says, did you do any type of a written notice to the sheriff or to the detention facility outlining this problem? You haven't been able to provide me a lot of concrete things, that steps that you took to make sure that your phone numbers were, and then you answer it. Do you see that?
Yes.
And what do you say?
I don't know what else you do other than talk, to Dan and Mike Gee and tell them of the problems. And then they tell you the problems. But I did a great deal of shit to do it. I didn't.
Thank you. I'd like to go to page stamp 2194, please.
I'm at that same page.
Same page, thank you. And then in kind of answering that same question, where you just cut off, you say, do what I normally do in a case, right?
Where at?
Just a couple lines down from what you just read.
Sorry. I'm trying to be here, trying to help you. That's...
You won't go through the whole thing. Let's just talk about this simple statement here that I want to I want to talk to you.
I'll agree with you, whatever it says here. It
Yeah.
says, I'm not trying to be flippant with it, I'm just
Of
trying to
course
find.
not. I just want you to look at page 18 and you see where you state, so that's a ton of stuff. Do you see that? But halfway down the page?
So that's a ton of stuff?
Yep.
Yes,
Read
I see
please.
that. So that's a ton of stuff. Why don't, do I read into the record? Can I just submit the record? I mean,
What I'd like to ask the question about is this. What you state is, so that's a ton of stuff. Why don't do it? Because nothing a jury hates more than a crooked cop. And if I can show that they were invading the attorney-client privilege, then guess what? That's a great trial setup, ... strategy on it. Why would ... why do you tell somebody that you're investigating them all the time? No, you give them rope to hang themselves. That's what you state, right?
that's what it says.
And what you're stating there, when you look at this in context, I know the court has the full record of this, what you're stating here is that you don't do more to alert ECCF about the phone numbers because you want for us to have enough rope to hang ourselves, right?
Absolutely not.
And-
Can I explain?
Well, you can, yeah, I'd like you to explain, given the context that right above there, Brad Tucker's asking you, why didn't you do more? I'd like you to explain what you mean by that, please.
Absolutely. From the beginning of this, I'm informed by a sheriff that he has an incident where he listens to my phone call, the first in 25 years that this has happened. I then have an incident where there is.
I'm asking you,
You asked me for
I'm gonna be
context.
Okay,
polite.
hold on.
I'm gonna be polite, but
No,
I don't.
Mr. Kaczynski, let's let him finish his answer, and just let him finish the answer, and then you can ask your question. Okay.
So then I have an incident in March 10th where the mail is read on it. I get an explanation that they actually didn't read it. I worked for the next probably 6 to 8 months to try to get him moved to a different facility to avoid this problem on it. When in good faith negotiating to try to have that occur. That is ongoing. I work with the AG's office, who I've at this point in time total faith in. They're going to assist me with rectifying the attorney-client privilege problem. I don't normally deal with the detention centers. I deal with the prosecutors because I can't control the detention centers, and the prosecutors always take care of the problems. It's just who I deal with. And so when they tell me, and when the sheriff tells me it's rectified, but we do whatever it takes, like when we go there and visit with a new person, we do whatever it takes to get through them. And so I'm working this continually to try to get this resolved. So I'm working on this with Jordan. It's just not me. This is Jordan, my firm. We're working on it. My client, me in Glendive, knowing the compromise situation on it. The only thing I can do at this point in time is try to get my client out of jail and institute things that, when I say laying rope at a person's feet, that means that you put a rope at a person's feet, that means they can save themselves or they can hang themselves. And so when I put and have a call on it, I clearly state that I'm his attorney and it should not be listened by. I believe fully at this point in time that you, at this point in time, I believe actually at this point in time, you're assisting me to try to actually get this to stop. And I can't figure out why they keep doing this, but I don't even know if they're doing it. I figured they listened to the AG's office. I figured they listened to it. But in my mind, laying the rope at someone's feet means you always give them a way to save themselves and hang themselves, but you don't trick them. And I didn't do anything like that. I just made sure that on these calls, it was announced that I was his attorney. And so when they call our office, it's first thing that's out of the mouth of our receptionist. We've reached Reed Bell and Jasper. Same way when I get a call on my cell number and it says you're receiving a call from a detention center. As soon as that picks up on it, before I start talking, I make it clear that I'm his attorney. And I ask them nicely not to do it. And I know from working for 25 years in every other detention facility, it's a matter of just simply putting my number there. I can't make anybody in a detention facility do anything. All I can do is make sure that I've made my statement to see that they know it's attorney-client privilege. I don't know if they're honoring it or not. It wasn't until the conclusion of the investigation that was done that I had an idea how bad it was.
Okay, we definitely answered the question.
Thank you, Your Honor.
Go ahead.
So, this 2194 bait stamp, page 18, the part that we just read, you would agree, though, that you're being responsive to the question at the top of the page. Did you do any type of a written notice to the sheriff or the detention facility outlining this problem? And then you would agree that what you just said about the rope is answering that question.
I did not. I was asked to call in.
I'm sorry, I'm just asking you, do you agree that you're being responsive when the paragraph starts, so that's a ton of stuff, you're being responsive to Brad Tucker's question about why didn't you do any type of written notice? Would you agree?
Yes.
And at the very end of that, you say, no, you give them rope to hang themselves, right?
Exactly.
Thank you, sir. I'd like to go back just briefly. I'm not going to spend a lot of time on this, but this Trent person that you saw in the note, right?
Yes.
You were pretty clear earlier that the only way we would have known about Trent and Sterling and the job would have been if we would have listened to some sort of privileged communication. Is that right?
No, that's not what I said.
Okay, could you clarify that, please?
Yes. That this note, what I'm saying, this individual on it, to put that note in there. If you look at the way in which it's put in, it did not come from a normal source, like video, call, that type of thing. This individual, Desiree Riley or whatever it is a detention officer. And so she wrote in a note and linked it to a source, okay, on it. And all of the other sources are like video calls, phone calls, and all of it. It has a source on it. The only other sources that it could possibly be, in my opinion, is from a meeting that I would have had from my client or from reading my client's mail.
And so when you say source, you're saying a source for the note, right?
For the comment that she wrote.
The comment, yeah. And the comment was?
Exactly what it says.
And just tell me what it says.
I read it.
I don't want to hear all the numbers, I just want to hear what it says.
Trent broke his jaw, not worse.
Trent broke his jaw, not worse, right?
Correct.
And Trent was an inmate of Mr. Brown's?
Well, what?
Were they inmates together?
I'm not going to go into what Trent
I'd like
is.
to approach you if I could, Your Honor. Here you was marked as bait stamp 63, 64, and 65. Do you recognize those documents?
I do.
And what are those?
Dan, can you please tell me which one this is so that I can
Oh, I'm sorry.
participate as counsel just like you are?
So these are bait stamps 63, 64, and 65.
Is this a number in your binder that you gave me?
No, this has not been a stipulated exhibit.
So do you have a copy for me?
I don't, but
Or just tell me what it's from.
this just came up when Mr. Trent was discussed earlier.
Okay, I have this. Thank you.
Yep, thank you. Can I approach you?
How long did everybody say nice?
You said you recognized that. What is that?
It's part of the investigation that was completed in the homicide investigation.
And who's been interviewed on that page?
It talks about Trent.
And the interview is summarized in a number of pages, isn't it?
It is.
Thank you.
So I understand, Mr. Desi, what you just showed, Mr. Jasper, was an interview with someone named Trent.
Yeah, I'm sorry, Your Honor. Yeah, it's an interview of somebody named Trent Robert Gress, Gress, and it's from Brad Tucker's investigative report. And it's date stamp 63, 64, and 65. It's not my intention to introduce it.
What date was that interview taken?
The date is February 14, 2023. And it was at 3:24 p.m. Would you like to have a remark, Your Honor, received by the court?
Right, I don't require it, I just simply wanted some reference.
Thank you. Give a moment, Your Honor.
Yes.
Did you ever utilize the free call that inmates can have at the Dawson County Detention Center where there's no charge to them and you can have a private room?
Never told about it.
Mr. Jasper, thank you for taking the time. Your counsel may have some additional questions.
Judge, I don't have any middle ground to cover.
Appreciate that, thank you, Mr. Jasper. Not right now, no, I think I'm good. I'm gonna let you get back to counsel to get this order.
Thank you.
Thank you, Your Honor. So the purpose of the testimony of, we'll start with Justice Nelson, is not that of a judge. It's not that of anyone offering legal opinions. Instead, it would be his testimony as a former county attorney, as someone who's been involved in criminal investigations, including felonies and homicides. And the important piece of his testimony that we would have him testify about if permitted would be how the investigation works, how it's fluid, how there's different information from different sources, and how it would be difficult, if not impossible, to track down prejudice in a case. And the fact that you can come up with different sources for information does not in any way, shape, or form mean that that information didn't also come from a tainted source. And there's simply no way to verify that. That's true in a case with a single breach, and that is particularly true in a case with multiple dozens, at least the state's agreement that there's 19 phone calls, 12 different people from 5 different agencies, including DCI and including Prairie County. It's simply impossible to get there. He would offer testimony consistent with his declaration, which was submitted, as the court pointed out, it's document 140. In particular, he would talk about paragraphs 21, paragraphs 14, paragraph 16, paragraph 17, and paragraph 19. And he would talk about the norms and standards of detention centers and prosecutors and investigators, how they know or should know about the attorney-client privilege, the steps they should take to protect it, the fact that you don't need to and shouldn't need to have to log your number, the fact that you shouldn't have a form to fill out, and that if there's a sheriff who calls and alerts the facility directly, nothing further should be required. And then finally, talking about the fact that if there's an internal affairs issue like this, you need a truly independent entity to come in and investigate. Certainly not, with all due respect to Sheriff Lewis, somebody who was involved in listening to the calls, and likewise, with all due respect to Agent Tucker, somebody who's involved as the principal witness and principal investigator in the criminal investigation against our client. And then Ms. Hood, moving to her, her background is stated in her CV. She would provide similar testimony except from the position of a criminal defense attorney, someone who has worked in rural counties, someone who has worked with rural jails, someone who has represented all different kinds of defendants charged with all different kinds of crimes, talking about the different information that you need to obtain from your client, why it's important to communicate with them by mail, in particular with those clients, also by telephone, why in her experience she never had to register her number, why she never had to fill out a phone blocking form, and why she understood and believed throughout the course of her decades-long career that her communications with her client were protected, just as Mr. Jasper had described. And then she likewise would address paragraphs 21, 14, 16, 17, and 19 from Justice Nelson's affidavit, and her testimony would be that she concurs with him, not from the perspective of a former prosecutor, but from the perspective of a criminal defense attorney, and most importantly, Your Honor, that there is no way, absolutely no way for the court or for anyone to say with this level of attorney-client violations that it didn't seep in and taint the investigation and the prosecution, and there's simply no way to protect Sterling Brown's rights under the circumstances. Thank you, Your Honor.
After hearing the opposite proof, I will still follow through the order that I've already put on the record. Using all of that, the excellent cross-examination material for Agent Tucker. I also think that Mr. Jasper has set forth his experience of 25 plus years as a defense attorney in the state of Montana. Pretty concise explanation for what the norms are in his new facilities and what his practice has been. Take notice of that. Okay, any additional witnesses beyond Justice Nelson and Ms. Hood?
No, Your Honor. Thank you for the chance to make the offer proof.
Absolutely. Okay, so we have an hour. Are there witnesses present for the state that you would like to call at this time?
November 16th of 2023. It's called Notice to the Court. During our hearing with the judge in Chambers, Judge Raven Chambers, there was representations by Mr. Jasper that the state could only know certain facts by listening. And then the notice to the court that was provided is how the state gathered that information in that scenario, Your Honor.
It's a November 16th, 2023 filing.
Yeah, and I can get the document number before we recess.
Okay.
Can I respond to that, just briefly, Your Honor?
Sure.
The only point that I'd like to make is that this just illustrates the impossible position that we're in, where the conversations and the letters that our client has with his attorney, we are foreclosed and are completely protected in terms of the content of those conversations. And in order for us to refute this and to link it up, we have to disclose information that we cannot disclose and we cannot do without violating our client's rights. So it's completely impossible and impermissible for us to be in a position where we have to refute something where we cannot provide that information. That's the fundamental problem here, Your Honor. Thank you for that chance.
Am I going to hear from Dee Riley?
Your Honor, she, I believe, was subpoenaed by defense, or at least a subpoena was submitted. The state doesn't have her subpoena. We're happy to bring her for the next day if that's important to Your Honor.
Well, she seems to show up a lot in those calls. I just was surprised I haven't heard from her. And I have learned enough in 7 years as a judge to know that I only know what I need to know. If there are reasons that she is not being called by either side or both sides, that's your choice. I just see
I'm
that.
happy to explain why, Judge. She was subpoenaed on it. She no longer works there. She's privately employed. She had 14 appointments, meal appointments scheduled. She basically said that it would be such a financial hardship for her that we agreed to release her because one of their witnesses had taken over her position and essentially during a lot of the questioning time actually done a lot of the work on it. So he, the individual, I can't remember his name, that sat with us during it, controlled the computer. So we felt like we had a witness that replaced her and didn't want to cause her financial hardship. And that's exactly what happened.
No, I appreciate that, Mr. Jasper, thank you. And is that Conrad?
It is, Your Honor.
Who sat during the examination that was there?
I wasn't there, Your Honor, but that is my understanding, yes.
Okay, all right. Let's call witness.
Okay, thank you, Your Honor. We will call Lieutenant Conrad, or excuse me, Captain Conrad now.
Last name is C-O-N-R-A-P.
Thank you, Your Honor. Captain Conrad, how are you employed?
I work at Dawson County Correctional Facility.
How long have you worked there?
A little over 13 years now.
And what is your current title?
I am the captain.
When did you transition to that role?
I don't exactly remember. I've been captain probably for at least 4 or 5 months now.
What are your duties in the course of your employment as the captain at Dawson County Correctional Facility?
So as captain, I am the unit manager and the chief of security. I oversee our stateside chief security. I oversee officers, the safety of the public, the inmates, and our officers as a whole.
And prior to 4 or 5 months ago, what title or rank did you hold at DCCF?
Lieutenant,
And what was your role in that capacity?
chief of security,
Did you have a designated side or was it for the entire facility?
entire facility.
How long were you in that role?
About a year.
What was your title in February of 2023?
Sergeant.
What were your duties at that time?
I was in charge of day shift. My job was to make sure that the day-to-day operations for pretty much stateside got done. That was moves, transports, things of that nature. I did have a corporal, and they ran county side for me. But if they needed assistance, then I would step in and help them.
And you referenced a corporal. Is that the lowest rank there is at DCCF, or is there another rank below that?
Officer.
Officer? Okay. So the bottom rank when you're starting out at DCCF is a detention officer?
Correctional officer, detention officer, yeah.
So we've covered a lot of ground in the last 2 days while you've been here, so I'm gonna kind of fast forward ahead. And we're gonna get into inmate phone calls.
Okay.
What is the policy at Dawson County Correctional regarding monitoring recorded inmate phone calls?
So the way that we handle phone calls, pretty much any supervisor or administrator can go into our IC Solutions account that we've made, and they can look at our phone calls to see who that inmate is calling, what number they're calling from. They can listen to the phone call, they can make notes, things of that nature.
And in your experience with the IC Solutions platform, can those listens be modified? Could you go in and make it so you can't tell that you listened to a recorded call?
No.
And if you make a note in that system, could you then delete that note and have it not appear?
I'm unsure on that. I know that you can make a note and you can delete a note, but I don't know if it records that or not.
Generally, in your experience, why do Dawson County Correctional staff listen to inmate phone calls?
Due to safety and security. Not all the time, but sometimes inmates like to talk about stuff that goes on inside the correctional facility, whether it's a fight that might have happened, pre-cases that might have happened, things things of that nature. So we listen for that. It's just good information.
I'm going to ask you a perhaps unfair question. You just said PREA. Can you tell us what that acronym means?
Prison Race Elimination Act.
Okay, that makes sense. Thank you. And so you're listening to those calls for things that may be going on inside the facility. What, if anything, are you listening for in terms of things going on outside the facility?
There are instances where sometimes the public or family or friends send things through the mail that they sometimes talk about, that they try to get in through the mail system to the inmate, and we stop that if we can.
What, if any, policy is there for a situation where a DCCF staff member may determine that a recorded call that they've listened to is between an inmate and their attorney?
Can you repeat that? Sorry.
Yes. What, if any, policy is there for a situation where a correctional facility staff person or teammate may have listened to a recorded call and determined it may have been between an inmate and an attorney?
So generally if that happens, if an officer is listening to a phone call, typically it's not an officer, pretty much all our supervisors and above can listen to phone calls, but if that happens, they can make a note, or they can go up to, if that's a corporal, they can go to their sergeant, and then the sergeant can make a note and then bring it up to our attention and report it, and then we go from there.
And in that process, what should happen once that's reported?
So typically, if we think it's an attorney, we can advise our supervisors to not listen to that number while we verify if that is an attorney or not. We can call that attorney. If that attorney would like to fill out paperwork to become a verified attorney and does not have their number recorded, they can go that route.
Insofar as you're aware, Captain Conrad, is that a written policy that exists at DCCF?
A written policy? I'm unsure if it's written. I know that that we've had attorneys fill out paperwork before and then do it.
And is there a written policy about what staff members should do if they encounter a situation where they're listening to a recorded call that may be involving an attorney?
Definitely report it to their supervisor and then write a report of what transpired, of when they listened to it, what they heard, and then turn that into registration.
And you referenced a form to verify attorney phone numbers, is that correct?
Yes,
Are you aware of when that form process was instituted?
I am not. I know that when it came about, I was still a sergeant, so I wasn't involved in that.
Would you have any reason to dispute that it was not a process that was in place until after November of 2023?
I could speculate, I guess.
Fair enough, you don't know. So you also talked about verifying whether the person is an attorney if someone were to run into that situation. How would you, in your practice, go about doing that?
So if one of my supervisors listened to a phone call and they reported it to me, are you asking like that or?
Yeah.
If they reported it to me, what I would do is I would listen, I would write down the number that was given to me, read the report that was given to me. I could then Google it, if there was a name mentioned, I could Google that name to see if it's an actual law firm or not. Our mailroom officer is actually really good with remembering attorneys, I could go to her and ask her if she knew or not. If we did think that it was an attorney, then we try to make contact with that attorney and verify through them if it was or not. If it is their number, then we would want them to fill out that paperwork with their name and what numbers they use to contact the facility.
And you referenced a mailroom officer, just for clarity, is that Officer Nichols?
Yes.
And so that process that you would follow, is that the same process that everyone follows, or is that your personal practice?
I oversee that stuff, like the mail. Kind of one of my new positions, one of my new duties, I guess. I'm still learning, but that's how I would do it. That's how I would instruct anyone that took over my position on how to do that as well.
Okay, so it's fair to say that for at least the last 4 to 5 months since you took over as captain, that's been your practice?
Yes.
What is your understanding of which agencies outside of the Dawson County Correctional Facility have access to IC solutions?
I know that we have access. I believe probation and parole have access. Obviously, DOC, MSP have access to IC solutions. That's kind of my understanding.
Okay, and just to be clear, DOC is the Department of Corrections?
Yes.
And MSP is the Montana State Prison?
Yes.
What's your understanding about whether civilians have access to IC solutions?
Civilians, typically, no. We try to stay with us, law enforcement.
Why is that?
Safety and security, information, personal information. We just don't want anyone diving into our system, listening to phone calls, getting information, and stuff like that.
And if additional agencies request access, additional law enforcement agencies request access, how would they go about getting that access? What has to happen?
They have to contact us, me, request why they want access, whether it's usually a detective doing an investigation on one of our inmates. I will write down their name and number, what agency they're with. I will talk to the warden to make sure that we can give them access. And if we do, it's limited. Usually just monitoring and making notes.
Okay. So they wouldn't have, for instance, the ability to block numbers?
No, they shouldn't.
Do you, in your current role, listen to inmate calls?
Yes.
How much of your day is spent doing that?
Some days more than others. It depends on what I got going on that day.
And in your previous role as a lieutenant, did you listen to inmate calls?
Yes.
How much of your time would be spent doing that when you were a lieutenant?
Probably a little more. 'Cause I was a lieutenant, didn't have a captain, so I had a little more time on my hands.
And what about when you were a sergeant on the day shift? Would you be listening to jail calls during that time?
Yes, not as much. That was more of like making sure my officers did their job. But yes, I did some phone calls as a sergeant.
In each of those roles, when you're listening to jail calls, where would you be doing that?
In my office. As a sergeant, it would be in the sergeant's office. And then as lieutenant captain, I have a separate, I have my own office that's away from everybody else.
Can you describe for us the sergeant's office?
Sergeant's office has a desk, a couple computers. It holds information about all the inmates that we house there for the time being. It is accessible to myself, my corporal, and other officers.
Is there a door that shuts?
Yes, anything locks as well.
When you were a sergeant and working out of the sergeant's office, if you were listening to inmate calls, was the door open or closed generally? Closed?
Yep.
And what about as you shifted into your role as lieutenant and now as captain, when you were listening to jail calls, where were you doing that?
in the lieutenant's office and the captain's office.
And do those offices have doors?
Yes, they do.
Would you listen if the doors open or closed?
Close.
Why is that?
So, the hallways, when we're doing moves, there are inmates that move about when they go in the library. For safety and security reasons, we don't want other people hearing, especially inmates hearing what I'm listening to. There are times that you can lock the door and officers couldn't come in and listen to phone calls. Most of the time, it was just me.
So in your training and your experience with IC Solutions, are you able to kind of fast forward in a call from the point the phone picks up and the inmate's doing the entry of their phone number they're calling and their PIN? Can you fast forward through that and get to the point where people are actually talking?
Yes.
Was that a normal part of your practice, or would you listen from the very beginning of the phone being picked up?
When I first started out, I did listen to the whole message, and then as I kind of got used to it, I would just skip to the very beginning of the recording, totally up when people were talking.
And is it accurate in your experience that there is a portion of that call that's being recorded on the inmate side before the conversation starts?
Yes.
What is your understanding of the impact of that fast forwarding process to get to the point where the conversation starts on what percentage of the call shows as having been listened to in IC Solutions?
From my understanding, it does impact. I think it shows a little bit of percentage listening to it.
And in your experience, is the verbal warning that this call is being recorded played at the beginning of every call that is in fact being recorded?
Every call.
Okay, we're gonna shift gears and get to why we're here. Are you aware that Sterling Brown was a defendant at the Dawson, or excuse me, an inmate at the Dawson County Correctional Facility?
Yes.
Did you interact with him while he was there?
Yes.
Did you listen to any of his jail calls while he was there?
No.
Were you asked to participate in a testing process related to this issue of the calls between the defendant and his attorney or his attorney's office?
Yes.
And did you facilitate that testing process?
Yes.
And that occurred at the Dawson County Correctional Facility, right?
Yes.
We heard some testimony that the witness, or excuse me, the expert retained by the defense in this case had sought out to have her own account created to have access to the Dawson County Correctional Facility's IC Solutions platform, and that was not allowed. Is that your understanding?
Yes.
Why was that?
So the
Objection, speculation.
Do you know why it was not allowed?
the warden is the one that made that call, so I can't speak for the warden.
You can tell us the warden made a decision.
Yes.
You want to tell us what the warden said, or not what the warden said, tell us what the warden's decision was.
The warden made a decision to not give her access to IC Solutions.
Thank you.
And so as a result, you participated in this testing process. Who would you describe as having been in the driver's seat, if you will, for navigating the correctional facility's IC Solution platform?
I was the one that did all the clicking and the typing and all that stuff at the request of the defense of what they were looking for.
And we have also heard testimony that there was a request during that process to do some testing of the live play option. What is the live play option?
Live play option is where you're actually listening to a phone call that is going on at that time.
And were you able to honor that request?
I was not.
Why not?
Due to safety and security reasons, there were inmates being transported outside the facility, and anytime that is happening, the phones are turned off for state and county side.
When you, I'm gonna take a minute to recollect my question before I ask it. Captain Conrad, when you concluded that testing process, were you asked to come back for another round of that testing or additional testing?
I don't believe so.
Would you have done so if asked?
If I was requested, yes.
Have you had the opportunity to review the call log information, not the calls themselves, but the call log information pertaining to Mr. Brown's jail calls while he was an inmate?
Sorry, no.
Have you seen any sort of document or spreadsheet about inmate calls that Mr. Brown made while he was at Dawson County Correctional Facility?
While he was incarcerated, I don't believe so.
So you've had no involvement with his inmate calls?
No.
Insofar as you're aware, are users in the IC Solutions platform that Dawson County Correctional Facility uses able to manipulate the data in any way?
No.
Governor, may I have a moment? So I'm going to ask you the last couple of questions just to have a very clear record. Have you at any point in time heard from anyone about the substantive content of any of the any of Mr. Brown's calls with his attorney or his attorney's office? And as you consider that question, please do not say what that may have been, just have you heard any substantive information? Have you heard anyone talking about anything pertaining to these calls at issue?
No, other than when I was told that the defense was going to come, I was going to do the testing for the defense. That's calls had been listened to, and that's why I'm doing that, just to kind of get that information.
Okay. So you were told that there were calls at issue, and that's it?
Yep.
Okay. I don't have any further questions for you. Thank you. I think the defense will have them.
Okay.
Oh, sorry.
That's right. Just shivered. Captain Conrad, how are you?
Good.
Lance Jasper, I represent Sterling Brown. We met before, correct?
Yes.
On it, and there were occasions when I came to Glendive and visited Sterling Brown. Do you remember meeting me?
I do.
And during my visits, we had the opportunity to BS. Is that fair to say?
What do you mean by us?
When we were signing in, those type of things, did we have discussions?
Probably.
Okay. When you walk into the detention center as a visitor, what would you see?
When you're walking in, you walk through two double doors. Up to your right, you'll see a window where our warden assistant is at. Continue forward, you walk up to a desk. It's a glass in it with some log books on top. And you have a metal detector and a secured door.
As a visitor, what do you have a visitor do with regards to the logging?
So we're filling a logbook. They would sign in, they would put their name, the date, the time, who they're visiting, and why they're visiting. And then when they leave, have them sign out the date and time.
So when you have a new person that comes into the detention center and hasn't been there before, that may be an attorney or working with an attorney, do you do background checks or do you do certain things to make sure that they're able to basically meet face to face with someone?
If they claim that they're an attorney, usually they have some sort of ID, saying that they're here to see a client. Verification process through that.
Do you remember my visit when I came in and had already done that?
I know that you've been there multiple times.
Was there ever a time where you had told me that I needed to provide additional information to the detention center so that they knew that I was Sterling Brown's attorney?
I don't remember doing that.
When an individual comes in and says, I'm John Brown's attorney, do you type in something or do you do a search, or how do you determine that John Brown is the attorney for that individual?
So usually if someone comes in and they're claiming to be an attorney, I'll look at their ID card. There's been times where I've asked if they have proof that they're an attorney. If they don't have any, like I said, usually a mail-order officer knows most attorneys. I'll even go back and ask maybe an administrator, look it up real quick, and then if it pops up, then we can go from there.
Yeah. When I showed up, was there any problem with letting me into the visitor room?
No.
Okay. By your experience, training, and past experience working there, was there anything that made you think that I hadn't complied with what needed to be completed with the Dawson County Correction Facility to register and be known as Sterling Brown's attorney?
And I knew that you were an attorney.
Was it pretty obvious each time I came that we were going to be visiting Sterling, and you actually knew what day I would be coming?
Off the top of my head, I don't remember.
But when I had individuals with me working, do you ever remember having to do background checks for those individuals prior to me coming?
I believe so.
Thank you. On it. Was there ever a point in time that I refused to comply with any request that was made of me from the detention center to satisfy the requirements to see my client?
Not through me.
Did anyone in the department ever say, me or my firm wasn't doing something that needed to be done so that the detention center knew that I was Sterling Brown's attorney?
I knew that you were Sterling Brown's attorney. I guess I don't.
Like, as a sergeant there and working there, was it well known that I represented Sterling Brown?
Yes.
If the sheriff called the detention center and said, quit recording Mr. Jasper's phone calls on it, would you expect the detention center to stop?
If it came from the sheriff,
Yeah, from Prairie County.
we would still need the paperwork with your name and number so that we would have a copy of that.
If I represented to you that we've established that there was no requirement of paperwork on it, but the sheriff provided you with all of the numbers for me and my office and my associate on it, provides that to you and tells you to stop, do you expect the detention center to immediately stop doing that?
I would, me personally as a captain,
Yes.
if I got that phone call from the sheriff with numbers and everything like that, I would immediately go to him, let him know what I got, and then let him make that call himself.
And is there any reason for you to doubt that prior to me representing Sterling Brown and making my first visit, that I lined up with the department or the detention center, that you knew that we were the detention center knew that my firm was representing Sterling Brown, that we provided our information and phone numbers, and then also lined up the first visit that occurred just prior to his initial appearance on February 22nd of 2023. Do you have any reason to doubt that I took care of that?
I wouldn't know. As a sergeant, I wouldn't know all that.
Okay. With regards to the if I understand it correctly, you were the day shift sergeant,
Yes.
right?
Yep.
And so that would make you basically in charge of the officers during the shift that takes place during basically business hours, is that correct?
Yes.
And that was on the county side, correct?
That's well, it was both sides. As sergeant, I ran the entire building.
So if there were any problems with my visitation or information that was needed or anything like that, you would have been the person that would have been responsible for getting from me, correct?
If there was an issue, the lieutenant or the captain could have delegated to me, but I was never delegated anything.
Okay. You're not aware of any issue at all with my visitation or giving notice of my numbers or anything like that with the detention center, correct?
The only thing that I had information about was filling out the actual paperwork with your name and numbers. I believe a DCI agent did that.
Correct, and that was long after my client was already out of detention, correct?
I believe it was December, if I remember correctly.
Okay. So let me ask you this, what would it take in your mind to continue to listen to the attorney-client phone calls if I provided all the information, everything like that, and it was good to go on it? What would it take for the detention center to continue to listen to the calls, even though the detention center knew that the calls were attorney-client?
If, from my experience, if all the information was gathered and everything was filled out properly, they had everything, calls, I wouldn't be listening to these phone calls.
Okay. Would it take someone with more power? Would it take someone like the sheriff to say, keep listening? Or would it take the attorney, prosecutor, or someone to tell you to continue to listen even though you would know that those are attorney-client privilege calls?
Even if the sheriff told me to listen to attorney phone calls, I wouldn't believe that.
Okay. What if a prosecutor told me to do it?
It's a privilege. I wouldn't do it. I can't violate that.
Okay. So, do you have any idea of why that would continue to happen?
No.
Okay. With regards to, and I think you've already said this, but if you were listening to a phone call on the IC services phone system,
Yep.
and you heard right off the bat, this is Lance Jasper, attorney for Sterling Brown, you're not gonna listen to that, correct?
If I heard that,
Yes.
that speculation that you were an attorney, then no. I would turn it off, I would do my report, and I would turn it in.
Okay. Let's say you didn't know me, like that part, and you're hearing a call
Okay.
on it, and it just says, this is attorney for so-and-so on it. and please don't listen to the call. This is protected by attorney-client privilege. Are you going to stop listening or continue to listen to it before checking to see if it actually is an attorney?
I would continue to listen.
Why?
Anyone can say that they're an attorney. I've had people in the past say that there's attorneys and they weren't attorneys. They were just trying to hide information by saying that they're an attorney.
And so you'd rather just not take the effort to strike that. Sorry, bad question. I do that sometime late in the day. So rather than take the time that it would take to check and see if that is actually an attorney, the call that you're going to listen to on it, you would just listen to the call first.
I would go as far as I could. If they started talking about legal situations about the case, then yes, I would stop. But if they said I was an attorney and they weren't talking about anything legal, I would still listen, yes.
Have you read Agent Tucker's report into the violations of the attorney-client privilege?
No.
Were you interviewed?
Nope.
Okay. On it. In there is discussions about multiple individuals being able to listen to this as it was like live played and listen to calls where multiple people would listen to calls. Are you familiar with that?
Objection, Your Honor, foundation. He's just testified, he hasn't seen that before.
That's correct, he hasn't seen it.
Okay.
You can ask him if he has any information
Yeah.
about that.
Have you ever watched where officers as a group have listened to live calls?
In the sergeant's office, yeah, if it's just an inmate on the phone, there's speculation that there might be something going on, then yes, there will be more volunteers in the listening areas.
And part of the reason, would it be fair to say part of the reason that you listen to phone calls certainly is the security of the detention center, but it's also to provide information that may aid in the prosecution of the inmates. Is that correct?
What do you mean by like?
Well, if you get something really juicy that might aid in their prosecution, like they disclose that a certain witness might have really good information on something, that would be shared with either the investigating officer or maybe the prosecutor. Is that fair?
If there was, as me personally, if there was anything to do with legal and I wasn't involved in that case, I wouldn't listen to it. I know that there have been cases that I have been involved in, and I tell people that you will not listen to this person's phone calls due to my investigation.
Have you been asked, or the detention staff been asked, to monitor phone calls for investigators that are looking into crimes?
I haven't. Usually, if there's an investigation going on, officers are told to stay away from those.
I'm sorry, what's that?
If there's an investigation going on that is going to probably involve law enforcement, we're told to stay away from those phone calls.
Have you received, or are you aware of any instructions that were given with regards to my client, with regards to his phone calls and how they should be listened to?
No.
Where would those instructions, if they are in, where would those be kept?
I get, what are you looking for, I guess?
So we know for certain that my client's calls were being reviewed and listened to by detention staff, okay?
Okay.
On it. We know that notes were being kept by the detention center staff that was also listening, okay?
Okay.
On it. So how, as I understand now that you're a captain, how would we figure out who was responsible for telling the detention staff to keep track of like notes and put them down so that they could look at them later to see if they were important to the investigation or prosecution of my client?
I wouldn't know anything about that.
Did you review the notes that have been taken with regards to Sterling Brown?
No, the only time that I ever looked at notes is when I was with you guys.
On who gave you instructions that you were going to be sitting at the computer, basically operating the computer on the date of our visit?
Warden Tom Green.
And did you ask him where he had gotten those instructions?
No.
What did, to the best of your recollection, please tell me what the warden told you.
That Sterling Brown's defense team was in
Judge, I'm going to object. This is your side.
It is. Same.
Were you aware previously of what the judge had instructed to be made available to us when we came to the detention center?
Sorry, say that again?
Prior to appearing that day for the inspection we did, were you made aware of what was supposed to be made available to us?
What my job, what my role was, what I was told to pretty much do was just show you guys how to navigate IC Solutions and how it operated and recordings and all that stuff.
When we were there, would you agree with me that you did not have the necessary privilege, the highest privilege, to be able for us to see who may have deleted information or allow us access to see what we needed to see with regards to Sterling Brown's calls, files, to determine if it had been downloaded or altered?
They're the only ones that can alter records, from my understanding, is IC Solutions.
Would you agree with me? You told us that the warden had a higher password or a higher level of authority than you did.
Yeah, I think I remember saying that, yes.
Okay. And because he had a higher level of authority, we were unable to access certain areas, correct?
The only one that I couldn't, I believe, access was showing how someone listened to a phone call at 135%. Other than that, from my understanding, and I could be wrong, is I showed you everything else that you wanted to see.
Mr. Jasper, we are at 4:47. I still need to have a scheduling conversation.
Should we just stop?
Yeah, that's what I'm thinking.
Yeah.
Okay. So, Conrad, I'm sorry. You're gonna have to see me again another day, but I certainly have no objection to you hearing via Zoom.
Okay,
If you hung out for 2 days.
I appreciate that.
Pretty big work group. No.
I appreciate it.
All right. So at this time, then I'm going to excuse you from your testimony. You'll remain under oath. We cannot discuss your testimony or the subject of this testimony.
Yes,
You'll remain under oath.
Yes, sir.
Will you?
Thank you.
I need about 2 minutes in my office to check.
We got our subpoena issued in January 25th or 2025, and then pretty much February through May, we were kind of going back and forth with IC Solutions trying to get this data. It wasn't until the 21st of May, about 3.5 weeks before this hearing, that we got it in the mail. We got that downloaded into a ShareFile link, and our staff sent it to us and Stacy, and then we immediately realized that the audio recordings were in. They produced audio recordings as well. And so we let Stacy know that there were audio recordings in there, and then when part of our staff met with Stacy on June 4th to go over the scope of her review, we told her not to look at those, get started with reviewing and compiling her report. And then June 11th is when we got those documents, the data from this IC Solutions subpoena, to the state. And then when the state requested the report on June 13th, Friday, we didn't even have it yet. And so we were working through it, looking at it as we received it on Friday and then traveling to Billings, and then we did, yes, get it to the state Sunday afternoon, but to the extent this can help sort of lay out for you that there was no intention to ambush the state in providing it, that's kind of what we were looking to do.
So this raises two questions for me.
Sure.
One, why didn't you all let me know that we're having a problem with document retrieval from IC Solutions?
Sure. I mean, I think with the February hearing getting moved and recognizing the court's responsibilities and I mean, we just took it upon ourselves to keep working with them. Our initial contacts with them indicated they were going to get it to us, when we reached out in February, and then it just kind of kept dragging. And yeah, there could have been a point where maybe we could have come to you. I think it was just on us to try to get that figured out sooner, and it just didn't get to that point.
My second question then is, have the parties discussed, I guess, some sort of action by the court, given that we now know that IC Solutions has the raw audio recordings of the attorney-client phone calls, and they're just there. They're not in any protected capacity, it was incumbent on the parties to protect those once they received them, but does there need to be some sort of formal communication with IC Solutions to protect that information?
Your Honor, IC Solutions does this in almost, tons of the detention centers, so they would hold almost all calls anyways on it. I believe with regards to that, if we received the order actually from the court to retroactively order IC Solutions to do that, then we could do it. It's based on the review of their policy. It can be done on it. Mrs. Lear actually looked into seeing how that could be accomplished, and so we could look to have submit a motion for it. But they are, they normally, in a normal course, they do this for a living, and it's never, 25 years, never had a problem with it before on it. And so this is a situation I think that you simply looking for it.
Okay, I would like to see the parties have that conversation and hopefully submit something that can be stipulated to, so that we can at least button up the issue moving forward. Based on Ms. Lear's testimony yesterday, that there was ongoing access to some of these calls. I think that's at least the safest course of action moving forward.
And based on, Your Honor, based on her testimony too, that download is actually more concerning that it's in Dawson County downloaded somewhere than really into the IC Solution world, to be honest. But
well, I think that could also be handled with a court order. I think that I'm also interested the parties could reach language directing the Dawson County Correctional Facility to cease any access to Mr. Brown's phone calls and to ensure deletion of any materials that have been downloaded. I think that might be worth a conversation as well, to stop any ongoing access or sharing of any materials that may exist on any hard drives within the facility.
yeah.
So I would like to see the parties follow through on that after today's hearing, please.
Your Honor, one of the other things that I think is important.
I think Ms. Paddock has something on that issue.
Thank you, Your Honor. We're happy to work with the defense to iron that out. I think Your Honor will hear some evidence today that may clear up some of those issues.
I appreciate it, Ms. Paddock. And I see one of my criminal defendant friends here sitting in the courtroom. Remind me your name, sir.
Mr. Holliday?
Mr. Holliday, if you have a hearing today, it's not in here. It's probably with one of our standing masters. And so if you go out in the hall and you look on the calendar in the elevator, it's going to tell you the specific courtroom that you need to be in. Okay, so look for where the standing masters are, probably 6th floor. Okay, thank you, Mr. Holliday. These are my frequent flyers. Okay, what else did you have, Mr. Jasper?
Yeah, Your Honor, just the unusual situation here, and so to clear up maybe some confusion for the court, is that because there wasn't an independent investigation here, the prosecutor led the investigation into the attorney-client violations. And so what happens, this dump of IC Solutions actually isn't really a dump because they control, as their investigation into this matter, they actually have the access to IC Solutions. They could have actually been the ones providing this information. And then if the court remembers, we have a motion pending to be able to get all the emails and that information and then interview, even including the prosecutors and the detention on it. And so it's an unusual situation because we are normally two separate entities, the state and the defense, and then there would be normally an investigation in a matter like this where like a dump like this, that would be truly a dump. But in this situation, they're actually running the investigation in this matter. And so that's what I'm saying is they actually have the control of the IC Solutions and literally could call them and have it because they're investigating the matter. You understand what
I do. I think that hopefully we're going to get to Agent Tucker today. And hopefully there will be a spirited cross-examination, I'm sure, of Agent Tucker. And so that seems like all fodder for that. And we'll go from there.
Yeah, just so like that's also, just so the court understands the
Appreciate
uniqueness of it.
Mr. Crowl, I think we were at Exhibit P with our last
Correct.
exhibit. I would like to mark this again just for completeness
Totally.
of the record.
Yep. That sounds fine, Your Honor.
So, Q would be our next exhibit, and that will be the IC Solutions timeline.
Good morning, Slayer.
Good morning.
So you testified yesterday that you were retained in this case as to this specific issue on August 5th, 2024, right?
It was definitely August. Yes, August 5th.
And you drafted a report and you gave it to the defense, you said yesterday, on Friday at 3 p.m. Is that correct?
Friday at 2:49 p.m.
Were you surprised to learn yesterday that the state had received that report Sunday night?
I hadn't thought about it until now. I don't know.
So no.
I guess I'm surprised at this moment.
Sure, okay, I appreciate that. So you drafted a report Friday, essentially you completed it at least.
Correct.
Okay. And to do that report, you conducted testing of the IC Solutions system at Dawson County Correctional Facility, right?
Correct.
And that was on January 21st of 2025?
Correct.
And your report claims you weren't able to complete the testing that you wanted to do, right?
Correct.
And that was for 4 different reasons, right?
Correct.
3 of those were attributed to essentially limitations of the arrangements with DCCF. Is that accurate?
Correct.
Okay, and so that testing in January 2025 was 6 months ago, right?
Correct.
And no requests were made for additional testing arrangements in the past 6 months, right?
No.
And then the 4th issue that you raise with regard to this testing was that the IC Solutions response was incomplete.
Correct.
And just to be clear, you're not putting that on Dawson County Correctional Facility, right?
No.
Or Agent Tucker?
No.
Okay. That's just an issue with a separate privately held company.
Correct.
We talked a little bit about the percentage of calls yesterday, right?
Yes, ma'am.
And is it fair to say that essentially we don't know what they mean as we stand here today?
Can you ask that question a different way?
Absolutely. Is it fair to say that when you look at the percentages listened to in the Dawson County Correctional System, when you were there looking at it, those percentages listened to are vastly different based on your testimony yesterday from what you saw in the IC Solutions records?
They're different.
Okay.
Yes.
So hard to say.
Yes. Like you can still say that it's a percentage of something, but
Sure.
I don't know what exactly.
Okay, yeah, agreed. Would you also agree that in your experience listening to recorded inmate calls on IC Solutions, there's an introductory section of every call that's recorded that takes about 1.5 minutes, 2 minutes?
There are on the systems that I've personally monitored, yes.
Okay. And in your review of the information, would you agree that it looks like the only agency directly involved with investigating this case that listened to any of the recorded calls that we now know to have been between Mr. Brown and a member of the defense team was Prairie County Sheriff's Office?
I don't think I know enough about the investigation to be able to say that
Okay.
one way or the other.
Okay. If I represent to you that Dawson County Correctional Facility is not involved in the investigation, would you accept that?
I can't conclusively say that based on the notes that were added by Dawson Corrections Facility staff to some of these calls that appear to me to relate to an investigation.
Okay.
So no, I can't accept that, I'm sorry.
Okay, that's fine.
It may be true, but I don't have enough information to know.
I appreciate that. That's a fair feedback. So with that in mind, and those notes that you're talking about from the Dawson County Correctional folks, those were the notes about Mr. Brown talking to a child, right?
Yes,
And would you agree with my characterization that those notes were seemingly out of concern for that child's well-being?
can I look at them again?
Absolutely.
I think there are multiple interpretations. That is an interpretation of that comment.
So let's talk specifically about the Prairie County Sheriff's Office account and the data that you've been able to review with the understanding that you're not familiar with the intricacies of the overall investigation.
Okay.
Would you agree that that February 15th, 2023 call was listened to by a Prairie County Sheriff's Office account holder?
Yes,
And your understanding, based on your testimony yesterday, is that that was Sheriff Lewis, correct?
yes, from Agent Tucker's report.
And your understanding from Agent Tucker's report is that Sheriff Lewis immediately exited out of that call when he understood that it may have been with an attorney.
He stated that, but the Wilson report doesn't show that.
It's hard to tell from the Wilson report.
Wilson report says 209%, so if that may have happened, and maybe they went back and listened to more later, but this says 209% on the 15th. However, I would agree that in Agent Tucker's report, Sheriff Lewis did say that he immediately backed out.
Okay. And you got this stack of paper that I think is admitted as Exhibit P, as in Paul.
I don't recall the number, but yes, I think we're referring to the same giant stack, the subpoena response from IC Solutions.
Okay, and that was 103 pages of call records and some additional tabs related to recording access, the notes that we've talked about from the calls, and a document relating to Mr. Jasper's cell phone number. Is that correct?
Correct.
And was I understanding your testimony yesterday correctly that you took that data and made a program essentially to parse out and pull out data pertaining to only the calls between Mr. Brown and Mr. Jasper's cell phone or Mr. Jasper's office?
That is correct.
And am I also correct in understanding your testimony that there were 127 attorney calls listened to?
83 unique calls, 127 times.
Okay, and is that captured in Defense Exhibit N, as in Nancy, the red and white spreadsheet you put together?
Yes,
That's 3 pages long?
yes.
So Ms. Lear, you talked yesterday about the process to have numbers not recorded in your experience with IC Solutions. Do you recall that?
I think so. We're talking about the same thing.
Okay. Can we agree that had the process to verify attorneys' numbers been successfully completed, that their phone numbers would not have been recorded?
In my experience, if the jail had blocked that number, marked it as privileged, the calls would not have been recorded, at least on the systems that I'm personally familiar with.
And you're not aware of any documentation that confirms that Mr. Jasper or anyone from his office made a request to have their phone numbers listed as attorney numbers?
I don't think I can answer that question because in my review of Agent Tucker's report, it seemed clear to me that Sheriff Lewis made notifications. I don't know what form that documentation would take or what it looks like or how it's done, That's outside the scope of my investigation.
Okay, but in your routine work as a defense expert, you've not been provided with any documents from the defense that the defense notified Dawson County Correctional, right?
No.
And we talked about the pre-recorded portion of these calls that are being recorded via IC Solutions, right?
Yes.
Would you agree that that pre-recorded portion includes a warning to both the caller and the recipient of the call every time a recorded call is made?
Again, only on the systems that I am personally familiar with. I've listened to no audio in this case, but generally that is true.
That's been your general experience with IC Solutions?
Yes, and it was mentioned in Agent Tucker's report.
Okay. And that warning specifically says, in your experience, this call will be recorded and subject to monitoring at any time, right?
Correct.
And that's at the beginning of every call
Correct.
that's recorded.
Well, I don't know if it's on attorney calls because I've never heard them, but yes.
Sure.
Every other call, yes, it's always there.
Okay. So every single time a caller and a recipient have a call that is recorded on IC Solutions, in your experience, they are given a separate warning.
Yes, ma'am.
Would you agree that it's reasonable for an attorney concerned with protecting their client's privilege to follow up after they would hear a warning like that, if they did?
I think that, yes, and if that warning plays regardless of whether it's marked privilege, I don't know I just don't have that experience. But absent that, yes, I do think that's reasonable.
Be reasonable to do so by phone, right?
Sure.
By email,
Any way you could.
formal legal mail.
Yes.
And so, Ms. Lear, if we were to step back and look at an overview of this issue, we can agree at this point that there were calls that we now know were between the defendant and an attorney or a representative of his attorney that were listened to, right?
Yes.
And we can agree that should not have happened, right?
Yes.
And we can agree that listeners with administrative privileges could have verified the phone number, right?
Yes.
And should have.
Yes.
And we can also agree that the attorney-client privilege is a deeply important value, right?
Absolutely.
That has to be protected by the state,
Yes.
and that has to be protected by the defendant.
The defendant can waive, so I think it depends.
Sure, but it's the defendant's right to waive, right?
Correct.
And if the defendant is electing not to waive it, it's their job to protect their own privilege, right?
Yes, with the caveat, it's my understanding it has to be explicit, similar to Miranda rights.
Sure. Like a warning.
No, like you have to affirmatively, like you can't just, you have to say, I want to talk to a lawyer. You can't waive it just by casually saying, should I talk to a lawyer? Things, there's some nuance in there, but yes, the defendant has to waive the privilege. It's the state's responsibility to protect the defendant's rights.
And it's the defendant's responsibility to protect the defendant's rights too, right?
In so much as they don't waive them, yes.
And it's also the defense team's job to protect their client's rights, yes?
I would say so.
So Ms. Lear, as we sit here today, we can agree that every single one of those recorded calls would have had that same pre-recorded message as in any other recorded call in IC Solutions in your experience.
Yes.
And you're not aware of any emails from the defense team to Dawson County Correctional, right?
No, I'm aware of an email to Mike Gee from Jordan Kilby, but I don't know if he's with DCCF or not.
Totally fair. I'll represent to you that he used to work at our office.
Okay. And no.
And so you're also not aware of them having sent, them being the defense team, having sent a formal letter to Dawson County Correctional Facility about this issue, are you?
I don't know anything either way.
So that's 127 calls that were listened to, right?
83, 127 times, yes.
Sure. So that's 83 times.
No, it's 83 calls, 127 times. So some calls were listened to more than once.
Yeah, I'm with you there. So 83 calls that were listened to, there were 83 times the defendant and his team were told this is being recorded, right?
Yes.
And 83 times they did not follow up with Dawson County Correctional.
I don't know.
You were in the courtroom for all day yesterday, right?
Yes.
So you heard testimony about the legal mail issue, right?
Yes,
And you heard Officer Nichols testify, correct?
yes,
And you heard her testify that the defense team mailed envelopes to Mr. Brown, correct?
yes,
And that was about a week before the envelopes were opened on March 6th, right?
I don't remember the date, but it sounds about right.
And you're not aware of them having sent a letter at the same time to Dawson County Correctional saying, hey, my calls are being recorded, please stop.
I don't know anything about that.
Okay, and so we talked about, a moment ago, you referenced this email from Ms. Kilby to Mr. G about the legal mail issue on March 7th, right?
Yes,
And have you seen that email?
yes,
And would you agree that in that email correspondence, Mr. G told Ms. Kilby that the attorneys needed to call Dawson County Correctional to register their numbers?
I think so, yeah. It's been a while since I've seen it, but that sounds correct.
Okay. And would you also agree that Ms. Kilby responded that she had tried to do that, but it was after hours and no one answered?
I don't recall that, but maybe.
Okay. That's fair, it's been a while. Are you aware that Mr. Jasper participated in an interview about this specific issue with Agent Tucker on November 29th, 2023?
Yes,
Is it fair to believe that you've read that transcript?
I have not read the transcripts of any of Agent Tucker's interviews. He transcribed some things in his report,
Okay.
so if those match, then yes, but partially.
Okay. Yesterday, you testified that Agent Tucker was repeatedly asking about trial strategy. Where did you get that information?
From Agent Tucker's report.
And that's based on the transcription portions or the summary of his interview with Mr. Jasper?
Yes,
You're not aware of any time in that interview that Mr. Tucker actually said to Mr. Jasper, what is your trial strategy, right?
no,
And are you aware that Mr. Jasper himself introduced the idea of trial strategy in that interview?
I have to read the transcript to know for sure.
Okay. Would it surprise you to learn that he said, if I can show you that they were invading the attorney-client privilege, then guess what? That's a great trial strategy.
Yeah, that sounds reasonable.
Would it surprise you to learn that he said, why would you tell somebody that you're investigating them all the time? No, you're gonna give them rope to hang themselves.
If it's in the report and you want to show it to me, I can refresh my memory, but I hesitate to say, yes, that's true when I can't recall, I'm sorry.
Yeah, that's fair, Your Honor, may I approach?
You may.
We are 6. Short, our exhibits. Okay.
Judge, I object to asking Ms. Lear to interpret or repeat Agent Tucker's report. Lance Jasper and Agent Tucker are going to be testifying, and this is also beyond the scope.
I'm gonna allow it with respect to beyond the scope. A lot of what Ms. Lear testified to yesterday and today is so far focused on her, not only the technological extrapolation of the data, but also on how she interplayed that information with the information that was in Agent Tucker's report. So I will allow Ms. Patton to show her the report that she said she has reviewed to see if it refreshes her memory as to the material she took into account in coming to her conclusion. I agree with you, that was about 7 levels of hearsay. And so we're not going to get into the accuracy or the truthfulness of any of those statements, just simply to refresh your memory of the report.
Understood.
And Judge, to be transparent with the court, this is a transcript of the interview, not the report.
She said she didn't
Very good, Your Honor, we'll deal with that.
Mr. Jasper, thank you. Appreciate it, thank you.
Absolutely. So, Ms. Lear, would you agree that what Mr. Jasper reported that's included, excuse me, what he said to Agent Tucker that's included in Agent Tucker's report that you have reviewed was his own disclosure of trial strategy, not Agent Tucker asking for it?
Again, I have to see it to remind myself,
Okay.
but I don't recall.
Do we have a copy of Agent Tucker's report?
Absolutely, Your Honor, yes.
Okay, so if we could do that, if we could give the witness a copy of Agent Tucker's report and then direct her to the specific area in the report that you're referring to and see if it refreshes her memory, and if not, we can move on. So I'll overrule the objection at this time, but let's keep moving.
Your Honor, if I can approach the bench. And for the record, we are referencing what has been stipulated, I believe, previously as State's Exhibit 16, which is a copy of Agent Tucker's supplemental report.
Any objection to the exhibit itself? I know the way that it's being used is your objection to, but.
No objection to the exhibit itself, objection to asking her to interpret the statement by Mr. Jasper or anyone else.
Okay, so understood. So we will admit State's Exhibit 16 at this time, and we'll allow Ms. Lyons to take a look, or Ms. Lear to take a look, and see if it refreshes her memory about the report itself. Go from there.
Does Pat have to give a page number? Lance was interviewed multiple times.
You bet.
So Agent Tucker's report, are you familiar with base stamp numbers?
Yes.
Okay, so we're looking at State's Exhibit 16. It's going to be base stamped pages 2119 through 2124. And to narrow the scope of the question that I've asked as you read through that to refresh your memory, where in that report did Agent Tucker ask Mr. Jasper for trial strategy?
I'll start by saying this is a summary of an interview with Lance Jasper. So Tucker may have asked questions that are not contained here. So you're saying if Tucker mentions in his report that he asked that question, where is that?
Yes.
I think I previously said I don't have any memory of him asking that.
Okay, you testified yesterday that he did.
But he asked him about trial strategy?
Yes.
I may have misspoke. I meant to say he asked him to disclose attorney-client privileged information.
Okay, so that may have been
If I said that wrong,
misstatement.
that was my mistake.
Okay.
I did not intend to say that.
Okay, we can move right along then. Thank you.
Thank you.
All right, so would you agree from your understanding of the case based on Mr. Tucker's report that's in front of you now, State's Exhibit 16, that Mr. Jasper told Agent Tucker that when the mail issue happened, when the envelopes were opened, they stopped talking about particulars in the calls?
I now also have to correct something I said earlier in your cross. You had asked me if I knew anything about the defense team reaching out to DCCF to set up the attorney-client privilege call system. Base stamp page 2119. There's a sentence where Lance tells Agent Tucker that he did contact DCCF and did raise the issue and did go through the process to try and set up attorney-client calls. So I'm sorry about that.
That's okay, and just to be clear, I asked you about documentation.
Okay, thank you.
And so that, your previous testimony is still correct, yes? There was no written documentation.
This is written documentation, but other
From
than,
the defense.
from the defense, no.
Okay.
Yes, thank you.
You two are starting to talk over each other, so let's be very careful, otherwise we might lose our court reporter and then they will be closed.
No one wants that, Your Honor, thank you.
And I'm so sorry. Can you ask the question again about the mail?
Yeah, absolutely. Would you agree that Mr. Jasper relayed to Agent Tucker that when that mail issue happened after that, so on March 6th of 2023, that mail issue happened, right? When that happened, they stopped talking about particulars in their calls.
If there's another paragraph, let me know, but I have one on page 20, on base stamp 2120. And it just says that during the interview, Lance said he couldn't think of a phone call with Sterling where he didn't only speak in generalities because they knew they were being listened to. Is that what you're referring to?
Yes, thank you.
Thank you.
And so, Ms. Diller, I'm sorry to make you kind of bounce around with exhibits. I'm looking back to your exhibit and that red and white spreadsheet of the call summary data. So as we're looking at that, if we bear the March 6, 23 date in mind when those envelopes were opened and count backwards from there, would you agree that that's 4 phone calls?
That's correct.
That's a call on February 15th, 2023, right?
Correct.
And then February 27th,
Yes.
and then March 3rd,
Yes.
and March 6th.
Yes.
And so based on Mr. Jasper's representation to Agent Tucker as relayed in his report, is it fair to say that after those 4 calls, there were no substantive conversations about the case?
Objection,
That's-
speculation, foundation. She hasn't heard the calls.
Stay, hold on.
So Ms. Lear, let's shift gears and talk about this flash drive that you got with the data on it from IC Solutions.
Yes, ma'am.
So you went and got that, right,
Yes.
on June 4th?
Yes.
And my understanding from your report and your testimony yesterday is that that ended up having these attorney-client calls on it, right?
Correct.
But you didn't listen to them.
No.
You were told not to,
Correct.
and you didn't.
No.
Your report criticizes the officers from Dawson County Correctional for listening to these calls, right?
Yes.
And that's for the amount of time that we have the data that shows us with the percentages that are unclear about their accuracy. Is that fair?
Yes.
And the same criticism for the Prairie County Sheriff's Office, right?
Yes.
And the same criticism for the Adult Probation and Parole Office, right? And for that one DCI agent from the Drug Task Force, right?
Yes, ma'am.
And so we take you at your word that you got this thumb drive and you didn't listen to those calls, right?
Correct.
And in your testimony yesterday, you testified that we have to assume they heard the whole call, right?
Correct.
So we don't extend them the same courtesy.
Can you rephrase the question?
Absolutely. So You have access to these same files, right?
Correct.
On a thumb drive,
Correct.
that no one can track if you've listened to them or not.
That is correct.
And we take you at your word that you haven't.
Yes.
And you're asking us to assume that contrary to what the officers who've been involved in this said in their interviews with Agent Tucker, that they in fact listened to every call the entire way through.
There's a difference here in that we have a percentage showing that, and they admit to having listened to at least a portion of the call. I'm not criticizing them for, in no way am I saying they're lying, they listened to the whole call. I'm saying the records and the data show that the percentage is not an accurate amount. I think if you were to interview them and ask them what percentage of the call did you listen to, I don't know that they could accurately recall. They can't remember the calls or what the contents were. I can tell you I've clicked on 0 of the calls, listened to none of the calls, and there is no record. And I'm also not accusing anyone who downloaded these calls of listening to them. I'm just saying it is possible that they could have listened to them and we would not have a record.
Okay. But we're not assuming that they did.
No.
Okay.
I'm just saying the listen percentage is not an accurate indicator of how much of the call was listened to or which portion of the call was listened to.
And you would agree we don't have any evidence that there was more listened to, other than the data you've already interpreted?
No, we don't have evidence to say one or the other.
Okay, so we're gonna shift gears and fast forward in time to, you testified yesterday that there were additional listens in the system after the motions were filed and this issue was brought before the court. Like since November of 2023, you found additional listens, right?
Thank you, yes.
Yeah, I'm sorry, that was getting confusing. So we found additional listens. Are you aware that the court in this case, previous Judge Rieger issued an order on November 16th of 2023 directing law enforcement not to listen to these calls anymore?
I'm not aware.
Are you aware that Agent Tucker emailed Mr. Jasper November 30th of 2023 about having the numbers blocked retroactively?
I remember something about that in Agent Tucker's report.
And are you also aware that Mr. Jasper responded the same day, refusing to fill out the Dawson County Correctional form?
Yes.
And are you also aware that Mr. Jasper received an email on December 1st advising him that the previously recorded calls were still in the system?
I'm not sure. Maybe if it's an Agent Tucker's report, then yes.
Okay. Are you also aware that Mr. Jasper on that December 1st email was notified that we're trying to retroactively block those calls but didn't want to inadvertently delete them?
Yes.
And are you also aware that Mr. Jasper sent a formal letter via mail to the Dawson County Sheriff's Office and to the Attorney General's office to preserve all evidence related to this issue?
I don't know anything about that.
So let's get into the facts of these later listen records that you found. Looking at your Exhibit N, we're back to that red and white spreadsheet. Would you agree that other than one listen on that first page of your summary report, I'm looking at the 4th line from the bottom, a November 24th, 2023 call?
I'm sorry, which page of the red and white spreadsheet?
It's going to be page 1 of the red and white spreadsheet. Okay. So down at the bottom, the 4th row from the bottom.
Yes.
Okay, we're looking at a call from November 24th of 2023, right?
Yes, ma'am.
I'm sorry, that's the listen date.
Yes, ma'am.
Okay. And the column to its left is blank.
Correct.
What does that indicate?
That indicates that IC Solutions did not provide records for the CSN 3244592 that would indicate on what date that call was made.
Is it possible that that's because that was a 0-minute call, like the call didn't connect?
I don't know.
And would you agree that that is the only call that was listened to subsequent to November 16th of 2023 by the Prairie County Sheriff's Office account?
It's my recollection that was the last call listened to by the Prairie County account, November 24th, 2023. Yes.
And would you agree that all of the remaining additional listen data that we have, for the additional listen records that we have, after that November 16th of 2023 date, all of those additional listens are attributable to Desi Riley's account.
I'm sorry, after what date?
I'm sorry, after November 16th of 2023.
Yes, I believe so. Well, there's a second account called D. Riley. I think it's reasonable to assume that may be the same person, but I don't actually know. But probably, same first initial, same last name.
I will go with you on that journey and reach the same conclusion. So, Ms. Lear, are you aware that then Captain Desiree Riley was asked to complete at the defense's request a copy of all of the recorded calls between the defendant and the defense team?
Yes,
And are you aware that that process was completed on December 7th of 2023?
that sounds about right. I remember something in December with Agent Tucker's report.
And are you aware that she had to do 2 different downloads to get all the data?
No, I don't know about that.
Would you agree with completing a download process on December 7th being consistent with the December additional listen recordings?
No, because I can't say that. That may be true, but all the data says is that it was listened to. And the data puts it in the same category from IC Solution as all the calls that have listened percentages. So while that may be a reasonable explanation, I don't have any evidence for me to be able to say that here as I sit now.
So it's possible, but you can't conclude that.
Correct.
And are you aware that those calls were downloaded to an EHD or an external hard drive and eventually mailed to Mr. Jasper?
Yes,
Are you aware that that was received at Mr. Jasper's office on December 13th of 2023?
I don't know.
Are you aware that Mr. Jasper and his team completed a defense interview of Agent Tucker on May 29th of 2024?
No?
If they had, and if during that interview they were notified that the state's download had missed October and November, would that surprise you?
You're asking me about things I don't know anything about. I'm sorry.
Okay. Let me ask it differently. If at the end of May of 2024, the state had been asked to download additional calls that were recorded in October and November of 2023, is that a reasonable explanation for the additional listens that occurred in June of 2024?
Objection, foundation, improper hypothetical.
Speculative.
Would you agree on page 2 and 3 of your Exhibit N, that red and white spreadsheet? So we look to the bottom 3 rows on page 2 of that spreadsheet.
Yes,
The listens of those 3 bottom calls are June 5th, 2024.
that's correct.
And as we turn to page 3, would you agree that with the exception of a listen that occurred in the middle on 1, 2, 3, 4, 10 rows up from the bottom, that being excluded, all the rest of the listen dates for these calls was June 5th, 2024?
That's correct.
All right, Ms. Lear, last topic. Would you agree that as we sit here today, you have not personally in the course of your retained service in this case seen any evidence that Agent Tucker has obtained any information from these calls?
No.
And you would agree that there's no indication that Prairie County Sheriff's Office listened to any calls beyond what was reported in Agent Tucker's report?
That's not correct. Agent Tucker did not mention the November 24th, 2023 listen, because I believe that is the same day that his investigation was taking place. But otherwise, yes, that's correct. It's just missing the one call.
You said that call was on November 24th of 2023, is that correct?
That's correct.
Okay, so I'm gonna have you reference back to State's Exhibit 16. It's gonna be Agent Tucker's report. So we'll look at date stamped page 2115, please. And we'll look at the bottom paragraph of that page when you get there.
Two one two five, last paragraph,
Yes, ma'am.
about the Post-it note to Nichols.
No, about just that bottom paragraph where we're talking about meeting with Sheriff Lewis.
2115.
Oh, thank you.
Oh, thank you, Your Honor.
All right, this one starts with on November 24th, 2023 at approximately 11:39 a.m. All right.
Yes, thank you. So Ms. Blair, would you agree that from Agent Tucker's report, it appears he met with Sheriff Lewis on that November 24th, 2023 date?
Yes, the same date, but previous to that call, and the interview ended before that call was reviewed.
Okay, and so if you would please flip to date stamped 2117, still in State's Exhibit 16.
And there, okay.
We'll look at the second full paragraph from the top.
Okay.
Would you agree that it appears from this report that they clicked on a 0-minute call?
They do, but it's a call from August 1st, 2023, and that doesn't match the call date for that call on November 24th, 2023.
And there isn't a call date for that data, right?
Correct.
Okay, so we don't know.
We don't know what date the call was placed that was listened to on November 24th, 2023 at 3:37 p.m., which is after this interview took place.
Okay, but we know they clicked on a 0 call on that date, November 24th, 2023.
According to Agent Tucker's report, they did. I have not reviewed the complete call data to see if any other calls were clicked on that day.
And again, all the rest of the listens were Desi Riley, right? After that November 16th, 2024 date.
Yes, ma'am.
And you would agree, as you sit here today, you personally have not seen any evidence that any information from these calls was shared with anyone, right?
No, I can't say yes to that question because again, we heard people testify that they were listened to in common rooms, but I haven't seen any affirmative, yes, definitely this was. People clearly shared information about things they heard on the calls with other people.
But you've not heard any evidence of that. That is your conclusion or assumption, right?
I think, can you ask that question a different way?
Yeah, absolutely. No one said, I told someone else about what I heard on this call, right?
That's not true. I believe it was Officer Olson that talks about, my word, gossiping with other staff about the content of Sterling Brown's calls. So people do discuss the contents of calls with other people who have listened to the calls. I don't think that's what you're getting at, but I'm trying to answer the question that you're asking.
I appreciate you. And so, finished out, you are not aware of any specific information from these attorney-client calls that you have not listened to having been shared with anyone else. You have no actual evidence of that having occurred.
Asked and answered.
Not answered yet. Go ahead, Mr.
Correct, because the problem is I don't know what's in these calls.
Very good.
I'm not aware.
Thank you. Appreciate your time. Thank you, Anna. Thank you, Ms. Lake.
Sounds like you and the state both agree that there's no percentage of calls that should have ever been listened to.
Attorney-client calls, correct.
And do you remember anything from Lieutenant Conrad about the introductory section of the call?
I do. He indicated that the jail accounts had that introduction set to automatically skip so that they did not have to fast forward through it or listen to it.
So it's safe to assume that the percentages or the portions of calls listened to probably didn't include that section.
Only for the DCCF accounts. I can't speak to the other accounts.
Sure. And there was some cross-examination about DCCF's involvement or lack thereof in the investigation. Do you remember those questions?
If you could be more specific, that would help.
Ms. Paddock was asking you to admit that there's no evidence that DCCF was involved in the investigation in the prosecutions of Sterling.
Something to that effect, yes.
In your experience in law enforcement, is that the case? That jail employees are not relaying information related to the calls to the investigative team?
My experience is that it's the opposite, that jail staff frequently interact with law enforcement about the contents of jail calls.
And based on your review of all the material in this case, is there any way of ascertaining whether that happened at this point?
I haven't seen anything that would show one way or the other if that occurred, just the notes that appear investigative.
There were a lot of questions about Bell and Jasper's request to block calls and how that should have happened from the state's perspective.
Correct.
You'd agree that in your experience that could happen by phone,
Correct.
email,
Correct.
in person,
Correct.
by asking what needed to be done?
Correct.
And based on your investigation in this case, is it your understanding that any level of privilege on the program at the detention center can block calls?
Anyone of corporal rank or higher, and corporal is my understanding the lowest rank.
Okay. And so would it have been possible for T. Patterson to have blocked the calls?
If she was a corporal or higher, yes. I don't recall her rank.
Yeah. And so do you have that red and white spreadsheet that was just referenced?
Yes.
Okay. And so on the first page under notes, you made a box that indicates on March 8th, 2023, the Prairie County account added a note to this call stating clicked on by mistake and did listen to the first couple seconds. Do you see that?
I do know.
Until I heard the name Tammy and did not recognize it as a familiar name for Sterling normal calls. This call was also listened to 3 other times.
Correct.
Do you have any idea why somebody would not listen to it and then proceed to listen to it 3 other times in 2 other months?
Judge speculation.
And yesterday you told me that it was clear and you always understood in your job that you were not to listen to attorney-client calls.
Correct.
But you also heard Taylor Patterson say that she kept listening even though she knew not to listen.
I did.
Did you review anything in your investigation that would have justified those actions?
No.
You haven't heard the calls, correct?
No.
You'd agree that Agent Tucker should never have access to attorney-client information?
If the defendant waives or the court orders it are the only times I can think of, but otherwise, no.
No one at DCCF should have it either.
Correct.
In fact, no one should have it except for the attorney and the client unless waived.
Correct.
There was a reference to calls on February 13th, February 15th, March 3rd, and March 6th in Ms. Paddock's examination of you just now. Did you see anything in your investigation that would have justified anybody listening to those calls?
No.
Ms. Paddock asked if we should believe you when you say that you didn't listen to the audio files.
She did.
Can you explain what the difference is between you and between Agent Tucker and the detention officers?
I am not acting as an agent of the state. In this case, I've been retained by the defense, so I only work with the attorneys for Sterling Brown. I don't just freely share information with the opposing counsel. They are agents of the state. They were asked to review these calls by Agent Tucker, who was investigating the underlying case.
And investigated Jake's case.
I don't know that.
Okay. And with all of this information that we have today, based on your investigative and forensic experience, what do you think would ultimately need to be done to figure out whether the information from the calls made it into either prosecution?
In my opinion, an independent, neutral third party, not associated with either side, would have to listen to every single attorney call and have some knowledge of the underlying investigation, because sometimes things might be mentioned in a call that if you didn't know the facts of the case, you wouldn't know were relevant, and then determine, was there anything relevant in those calls that links back to things that happened in the investigation on or after February 15th of 2023.
There was some discussion just now about retroactive blocking. And again, can you talk about the impact of retroactive blocking on the process of ascertaining what information made it into the investigations?
Judge, I'm going to object, ask and answer. We covered this yesterday.
To be direct, we'll allow.
Thank you.
Well, if you block the calls today and they delete them, then you wouldn't be able to independently investigate whether it made it into the investigation. Although you could always just assume it did and stop everything after February 15, 2023.
Referencing this chart, the red and white chart again. The downloads that occurred in June of 2024, or the listens that occurred in June of 2024. Based on your experience, is it appropriate for the user account D Riley to be downloading these, to be listening to these calls at this point at all?
No.
During your visit to the detention center, did you see anything about a download file category?
Yes, there is a download. The calls do show whether or not they were downloaded in the IC Solutions system.
Okay.
Or at least one call that I saw that was downloaded had that designation. And in my past experience, that exists as well.
And did you see anything in your review that indicated what ultimately has happened as a result of that download or with that call?
I don't know.
The November 24th, 2023 call that Ms. Paddock referenced and discussed with you, did you note the percentage of that call in Agent Tucker's report that Agent Tucker identified?
That call was not referenced in Agent Tucker's report.
Okay, were there any percentages of calls in Agent Tucker's report that were less than the percentages that you identified in your investigation?
Yes, and Agent Tucker only had access to the information up to the time of his investigation, whereas the IC subpoena IC Solutions subpoena has more complete and more data. So yes, they were different.
Okay. So as we sit here today, we still don't know what has happened with these calls and this information that's in them.
Correct.
And even if we did, is there any method or way that you're aware of to ascertain all of what has been shared at this point?
Absolutely not. Because of the common areas, because of the shared accounts, because of the small community, because of the talking amongst themselves. I don't know that you could ever track down every single person who may have heard something about these calls.
Okay, thank you, Ms. Lear. I don't have any further questions.
One area you just talked about. You were asked if Agent Tucker asked the people who listen to these calls to listen to these calls. You said yes, right?
I wish my memory was as good as yours. I was asked about Agent Tucker's involvement in asking people to monitor calls, yes.
Would you agree that the only agency he asked to monitor those calls was the Sheriff's Office from Prairie County?
In his report, that is the only one he references, yes.
None of the others?
Correct.
Thank you, nothing further.
I-F-E-R-L-E-W-I-S.
Thank you, Your Honor. Morning, Sheriff.
Good morning, sir.
How long have you been sheriff in Prairie County?
Almost 8 years as sheriff,
What did you do before that?
as a deputy sheriff.
And what other roles or jobs do you have in Prairie County?
Also the coroner, I was a canine handler, a fire warden. I think the list goes on, but that's the big ones.
Do you have any non-law enforcement jobs as well?
I own a hardware store in town.
And that's an ongoing enterprise?
It is, yes, sir.
Okay. Were you at the scene of the fire that led to the criminal charges that are at issue in the Sterling Brown case?
Yes, sir.
And is it fair to say that you were closely and are closely involved in that investigation?
Yes, sir.
Starting on the night of the fire and continuing up to the present day?
Yes, sir.
I understand you were at the scene multiple times?
Yes.
Spoke with witnesses?
Yes.
Responsible for securing the scene?
Yes.
Called in the coroner who did the evaluation here?
Yes.
Entered the apartment structure?
Yes.
Took photos?
Yes.
Completed reports, paperwork, those types of investigation items, right?
Yes, sir.
Did you direct the investigation up until the point that DCI and in particular Agent Brad Tucker took over?
Yes, sir.
And then after DCI took over and after Mr. Brown was in custody, Agent Tucker directed you to monitor Sterling Brown's phone calls from the jail, correct?
That is correct.
Did he also direct you to monitor the calls of the co-defendant, Jasper?
Yes, sir.
And did you do that?
I did.
And did you also direct your deputy sheriff, Jason Gray Eagle, to also investigate those items?
I did much later during the investigation.
And you started the task of listening to Mr. Brown's phone calls in February of 2023, correct?
That is correct.
And Mr. Brown was transferred over to the Dawson County Correctional Facility on February 15th, 2023, is that correct?
I believe that is the correct date.
And then you in turn listened to a call from Mr. Brown to his attorney on February 15th, 2023, the first day he was in the facility, correct?
That is correct.
And we'll cover cover this in a little bit more detail, but you also know from your investigation of this issue that Deputy Gray Eagle, your sheriff's deputy, he also listened to an attorney-client phone call on a cell phone number between Sterling Brown and his attorney at a later date, correct?
Yes, sir.
And Deputy Gray Eagle, like yourself, is involved in the underlying criminal investigation against Sterling Brown, correct?
Correct.
Like you, he is one of the investigators working on the underlying criminal case, not only against Sterling Brown, but also the case against the co-defendant, right?
Yes, sir.
And you testified at the co-defendant's trial in August of 2023,
I did.
and you were one of the witnesses called by the state of Montana, correct?
Yes.
And you provided evidence about what your investigation had shown, correct?
Yes.
And is it your expectation that if there's a trial of Sterling Brown, that you will be called once again as a witness for the state of Montana in the criminal prosecution of Mr. Brown?
Yes, sir.
Now, as far as the attorney-client privilege goes, is that something that you have been aware of since your first day as a law enforcement officer in whatever capacity that was?
Yes.
How did you learn about it? Is that from the academy or from some other source? Can you help the judge understand that, please?
It's something that we certainly talk about in the academy, but it's something that I've known about in my basically previous time prior to being law enforcement.
Any
There is that
specific,
privilege.
I'm sorry, any specific time where that came up that you recall?
No specific time that I can recall.
You're just saying it's a general understanding that there's an attorney-client privilege that protects the right of the accused to have confidential, privileged communications with his or her attorney, correct?
That is correct.
And is it fair to say that it's your understanding that that is a right protected by the constitutions of the United States and the Montana Constitution?
Yes, sir.
And is it fair to say that that is one of the most important rights that any criminal defendant has?
I would agree.
We heard testimony from some detention officers from DCCF who testified that they were trained to err on the side of caution when it came to protecting the attorney-client privilege, jail calls, jail mail, things like that. Is that your understanding as well?
I can't speak to what the jail staff, how they look at things. That's not my place.
Yeah, I guess the question I'm asking is, do you agree? Is it your practice? Is it your belief that you should err on the side of caution when you're dealing with the attorney-client privilege to protect that privilege?
Yes, as my office goes, absolutely.
And are you aware of any exceptions to that, sir?
No exceptions.
And is that how you train your staff as well in the sheriff's office?
Yes.
And that's how you were trained yourself?
Yes.
So one of the exhibits that we've had admitted is Exhibit O. It should be somewhere in the stack in front of you, or maybe the judge has it. It's the state's chart listing the calls. That's it, Your Honor, I believe. The one you just lifted up there. Looks like this. It's a table, sir. Kind of looks like this.
He has all the exhibits there.
Oh, perfect, thank
In
you.
your mark.
Yeah,
Okay.
they are not. I'm looking at
That-
That would
exhibit
be,
3.
that would be it, Chair. There are 2 pages.
2 pages, got it?
Perfect.
Perfect, thank you. So I will represent to you that this is a table created by the state. And what they were trying to do as best they could is capture the investigation of Agent Tucker and identifying the various phone calls that were recorded, the attorney phone calls that were recorded, and then which people listen to them or which usernames listen to them, along with the time of the call and the percentage. Do you see that?
Got it.
Okay. And so if you look at the very first row, it's identified as PCSO, which stands for Prairie County Sheriff's Office. That's your office, right?
That is correct.
And the very first column of calls there gives a date of February 15th, 2023, with a telephone call to 541-4100, and it identifies the length of the call as 6 minutes, 36 seconds. Are you with me?
I'm with you. Yes, sir.
And that identifies there that Prairie County listened to 79% of that call. Do you see that?
I do.
And that was you, correct?
That is correct. That is me.
And is that a call you listened to from the beginning? In other words, from the first time when Sterling Brown was talking to the person on the other side?
Yes, sir.
What do you remember about that call?
The only thing I recall from this is once I determined that Mr. Brown was talking to Mr. Jasper, that is when I disconnected the phone.
And if you listen to 79% of what's identified here as a 6 minute and 36 second phone call, if my math is correct, that's 5 minutes and 12 seconds of the call that you listened to.
That is roughly correct, yes.
At some point, as you were listening to it during that 5 minutes and 12 second portion, you realized it was an attorney-client phone call?
Yes, sir.
How did you know that?
I honestly can't recall. I believe I actually heard Mr. Brown actually state Jasper's name. And that's when I clued in.
And did the context of the call also clue you in, since Mr. Brown had just been moved over to DCCF and was making a call at that point in time?
No, there was no context prior to that that led me to believe anything different than just general conversation.
So your memory is that that call that day between Sterling Brown and Mr. Jasper was general content only?
Yes, sir.
And your memory is that it didn't involve anything related to his case?
No, not to my knowledge.
But the reality, and I just want to be fair to you here, is you don't remember the content of the phone call.
No, sir, I don't.
Prior to February 15th, 2023, had you ever listened to an attorney-client phone call between a criminal defendant and his or her attorney?
No.
Since that time, have you ever listened to a phone call between an attorney and a client in a criminal case?
Since the February 15th?
Yes, sir.
I will have to say no, I have not listened to any further phone calls.
So this was the first time, this was the only time, correct?
Yes, sir.
And then as far as the percentage goes, I'll move this along as quickly as I can, but there's an exhibit that we looked at, which is identified just for the record here as Exhibit N. If it shows a different percentage, if it shows that 209% of that call was listened to, do you personally have any explanation or understanding of why that might be?
No, sir, I don't.
Are you an expert at IC solutions?
No.
Are you a tech expert in general?
No.
Are you like me and rely on other people for that?
I do pretty good myself, but I would not consider myself a tech expert.
Very well. Once you realized that it was a call between Mr. Brown and Mr. Jasper, you stopped listening immediately, right?
Yes, sir.
And to be fair, you're 5 minutes and 12 seconds in the call, but you didn't want to listen to one more second, correct?
No, I did not.
And then the next thing you did is you got on Google, right? And did a reverse phone lookup.
Yes.
18 Forrest. Do I still have permission to approach that? I'll represent to you that this is a computer printout showing a Google search of the phone number 406-541-4100. And so the record is clear. This is something I did at my office purely for illustrative purposes. Do you have any objection to this?
No, I believe it would be Exhibit R.
R, thank you.
Thank you,
I
no
appreciate that.
Right, so there are the admitted, no objection.
And what shows here is that if you put in that telephone number, at least the very first hit I got here recently was Reed Bell and Jasper, local law firm in Missoula, Montana. You see that?
I do.
And then there's multiple other listings below that where the same law firm is captured by different websites and things like that, right?
Yes, sir.
Is this similar to what you did, Sheriff, when you realized, wait a minute, this sounds like an attorney-client phone call, I'm gonna stop, and then I'm gonna check the number and see who it is?
Yes, sir.
The moment you did that search, did you know it was an attorney that Mr. Brown had been talking to?
Yes, sir, I did.
Did you know that Mr. Jasper and his law office was already involved as counsel for Mr. Brown?
I believe I did know that.
So when you saw Lance Jasper, that was a name that was familiar to you already then?
Yes, sir.
Now, is there anything that would have prevented you, Sheriff, from looking up that number on the IC Solutions website before you clicked on the call and started listening?
If the number would have been vetted properly with DCCF staff, then we would not have been able to click on that particular phone.
Yeah, and I guess my question is just a little different. When you're looking at IC Solutions that day, it's February 15th, you know Mr. Brown's just arrived at the jail facility, you're gonna follow the direction of Agent Tucker and start listening to phone calls. You had the ability to see the number of the incoming caller before you listened to the call, correct?
I believe this was an outgoing call.
Okay.
But yes, you can see a phone number up in the corner of the screen.
Yeah, I appreciate that. You saw the number, you could have researched the number and determined it was an attorney before you listened to the call.
I could have taken those steps, yes.
And you didn't.
I did not.
And in retrospect, do you recognize that that was a mistake, sir?
I believe I could have done things a little differently.
What would you have done differently? And I realize we're here in June of 2025 with the benefit of hindsight, but with the benefit of hindsight, what would you have done differently?
The only thing I could have done differently was researched every phone number that came up first before we clicked on any of the phone calls.
And to be fair, it doesn't take long to pop the number in your phone and search it on Google, right?
No, sir, it does not.
Now, as soon as you knew you'd listened to an attorney-client phone call, you knew that was a serious issue.
Yes, sir.
And you took immediate steps to rectify it.
Yes, sir.
You immediately notified Prairie County Attorney Dan Rice.
Yes, sir.
You immediately notified PSB, Prosecution Services Bureau.
Yes, sir.
And Gazinski was immediately notified.
Yes, sir.
And you also immediately contacted the jail, right?
Yes.
Because as you already pointed out, there's some issue with them recording a call that's privileged, and you knew that at the time.
Yes, sir.
And so your goal was then to let the jail know, hey guys, we got a problem.
Yes.
Because in your experience, you would not want the jail to record an attorney-client phone call?
No.
Who did you contact at the jail to advise them that 406-541-4100 is the number of Lance Jasper, the attorney for Sterling Brown?
I apologize, I don't remember who it was I contacted. It would have only been one of three people.
And who would those three people be?
It would have been either Deputy Warden Kaiser, Captain Riley, or Sergeant Conrad.
And are all three of those individuals supervisor level, management level employees over at the jail at the time?
Yes, sir.
So they were people you were familiar with?
Yes, sir.
People you trusted to take action?
Yes, sir.
And in fact, I presume the reason you identify those three people is you've had interactions with them before?
Yes, sir. Those are my contacts there.
What level of urgency did you have in your message to the jail officer you spoke with about the seriousness of this issue?
I advised them that we have to have this number blocked. I made note of it in my system, which was my spreadsheets, but I told them they need to make sure this gets blocked.
And I presume you have a range of different conversations with the jail, ranging from stuff that's more mundane, scheduling things, all the way up to important things, health and safety items, stuff like that.
I think we need to understand what my role is with the jail, which is very little. They house my people for me when I need that, but I have no authority at the jail whatsoever, other than just trying to advise them to do things.
Understand, yeah, and I'm just trying to understand that there's some conversations you have with the jail that are pretty basic.
Yes, sir.
And there's some conversations you have with the jail that are much more important.
Yes, sir.
And you made it crystal clear to them that day that this was an important issue.
Yes.
And you made it crystal clear to them what phone number they needed to block.
Yes.
And based on your investigation that you conducted yourself of these phone calls, did DCCF block that number on February 15th, 2023 when you told them to?
They did not.
Do you have any explanation of why they failed to block the number?
They have a procedure in place to have phone numbers vetted, and they said that never happened.
And so if that would explain the February 15th call, why that was available for you to listen to, and to be fair, we disagree with that, but just I understand your answer. Can you explain why the calls after that date, after February 15th, 2023, why those calls were still recorded and available for different officers and government people to review and listen to?
I cannot have an explanation for that.
And do you know anything about the procedure that existed at the time, February 15th, 2023, for blocking an attorney number at the jail?
I do not know the procedure.
Don't know what forms, if any, were used?
No.
And don't know whether they implemented a new procedure and first required a form 9 months later?
No, I do not know.
Okay. According to my review of Exhibit O, which is that spreadsheet the state prepared, it appears that there were 15 phone calls from that 541-4100 number that were recorded after you notified DCCF.
Okay.
And is that consistent with your investigation too, Sheriff?
Yes, sir.
Now, if we look at that first row on this exhibit under Prairie County, we see a couple of calls to that 541-4100 number that were listened to after February 15th. So the first one is on March 21st, 2023, where it says 0%. Do you see that one?
Yes, sir.
And then there's also one on August 24th, 2023, where 10% was listened to.
Yes,
Do you know why or how that happened?
yes, sir, I do.
Okay, can you just tell the court so she has a full picture here?
It would, I guess it would help a lot if I had an exhibit to show you how this happens, but as we're going through, looking at all these phone calls, they're basically a big long list. And the best explanation I can give you is getting a little click happy, going through just listening to phone calls. You click on one, and then almost immediately a new screen pops up, and up in the right-hand corner of that screen is the large phone number. And the minute I notice it, I accidentally clicked on the 4100 number again. We close it right down. That's the 10%, 14%. But it's complacency of running through these numbers really fast, trying to get as much information as we can.
And you were doing all of this at the direction of the lead investigator who told you to monitor calls, right?
Yes, sir, that was my job at that point.
And again, to be fair, if DCCF had complied with your directive and blocked the number, then that click happy complacency issue you just described, that wouldn't have happened.
That would not have happened.
And it should not have happened.
That is correct.
You wrote a report in this case, correct?
Yes, sir.
Yes. Thank you. So Your Honor, that this is the sheriff's report, which I believe is an agreed upon exhibit.
It is.
And then the big spreadsheet is incorporated in the sheriff's report, but we printed it in a format where people with bad eyes can see it a little better, including me. So I don't know, do you want that exhibit S and T, Your Honor, or S1, S2?
Yeah, let's do the sheriff's report as exhibit S and T. Would be the spreadsheet. No, both would be without attachment.
Thank you, Your Honor. So you recognize exhibit S, your report there?
Yes, sir.
Well, when did you draft this report?
I honestly don't recall the date that I put this together.
Who directed you to draft that report and to perform an investigation into this issue?
I believe it was Mr. Tucker.
And we've heard a lot of testimony about listens and clicks and the IC solution, so I don't want to go through the particulars very deep with you here, but suffice it to say, does Exhibit S, your report, reflect what you learned during your personal investigation of the issue?
Yes, sir.
And then the spreadsheet marked as Exhibit T, that's the spreadsheet that came essentially from the IC Solutions data available to you at the time.
Yes, sir.
Had you ever put together a report like this before?
No, sir.
Had you ever analyzed IC Solutions data before?
No, sir.
Did you contact anyone at IC Solutions to get help interpreting or understanding this data?
No, sir.
Did you contact anyone from DCCF or any other law enforcement agency, detention facility, any other resource to get help in preparing this?
No, sir.
This is your own work then?
Yes, it is.
Is it fair to say, Sheriff, that you concluded that, based on your own investigation, that multiple different agencies listened to Sterling Brown attorney-client phone calls?
Yes, sir.
Did you also determine it was multiple different officials at those agencies?
Yes, sir.
Did you determine there were multiple different percentages of those calls that were listened to? And that included listens by yourself and by Deputy Gray Eagle in Prairie County.
Yes, sir.
What other agencies listened to these calls besides Prairie County and DCCF? Do you recall?
I believe there's one from probation and parole.
And Agent Tucker's report's in there where he's identified each of these different agencies. Have you seen Agent Tucker's report, by the way?
No.
His final report? I believe it's marked as Exhibit 16. It might be there in front of you. Looks like this, sir. Thank you for the help there, Judge. If you can turn to page 36, this will just take a second, of his report. And that's the page numbers, not those red numbers.
All right.
Okay. And listed in that page, you see this section here, Sheriff, where there's various users here.
Yes.
And so Prairie County is listed there, and then we have some folks from DCCF listed next, correct?
Yes, sir.
Can you tell the court who are these other agencies and people, starting with DCSO Sergeant Brian Bennett?
So DCSO is Dawson County Sheriff's Office, which I would have included in the DCCF. Montana Department of Corrections, which is the probation and parole. And then Montana DCI Drug Task Force. I apologize, I forgot about that they actually listened to a call as well.
Did you understand that the folks at DCCF, that they were also listening to Sterling Brown's phone calls?
Oh, yes.
And when you got on the IC Solutions system, there are notes that you can see where if a detention officer, for example, has listened to a call and he or she wants to make some notes in the margins summarizing the call or flagging important things. Are you familiar with that?
Yes.
And do you know that that happened with Sterling Brown's calls? You recall seeing those?
I don't recall seeing any from DCCF about attorney-client. No.
But what you do recall seeing are comments about other calls.
Yes.
Those were available to both you and to Deputy Gray Eagle.
Yes.
And likewise, at least to your knowledge, those would be available to any user who was on the system and had access to Sterling Brown's calls.
That is my understanding.
Did you view DCCF as a partner in this, in the case with Sterling Brown? Were they part of the investigation and handling of the criminal case?
No, I would not have viewed them that way.
Did you know that they were reviewing his calls for potentially incriminating or useful information?
I cannot speak to why they were reviewing his calls.
Have you had cases before where jail calls, jail conversations, information from a jailer has been useful to you in a case that you were working on against a criminal defendant?
No.
And you said that you'd consider the Dawson County Sheriff's Office kind of part of DCCF.
Yes.
Was the Dawson County Sheriff's Office involved, at least for you, in any part of your investigatory work or your office's investigatory work when it came to the case against Sterling Brown?
No.
Last exhibit. So this, I guess, would be Exhibit U.
Correct. Any objection from the state?
No, Your Honor, thank you.
You is admitted without objection.
Do you recall being interviewed by Agent Tucker?
Yes, I do.
And you knew that he was recording the conversation?
Yes.
Okay. And I'll represent to you that this is what we believe to be an accurate recording of your interview with Agent Tucker so that the record is complete here.
Yes.
And at least at the time you gave the interview, did you provide Agent Tucker with as much information as you were aware of?
Yes.
Now, did you find it unusual at all, Sheriff, that you were asked yourself to investigate a situation where you yourself and your deputy had listened to attorney-client phone calls? And I'm referring back to Exhibit S, your report.
I did not find it unusual at the time, no.
Did you understand at the time that that investigation would require you to evaluate things that your own office had done?
Yes.
Had you ever been asked to do that before? Kind of scrutinize what happened within your own office at the request of another agency?
No.
Did you consider it to be an internal investigation?
I guess I did not look at it that way at the time.
And if we divorce your office from it, and at this point, again, you directed the DCCF not to record the calls, they've done it anyway, they've listened to the calls, other people listened to the calls. Did you view it as sort of an internal investigation of another agency, in this case DCCF?
Yes.
And can you explain why you felt that way?
I guess I felt that way more because I had asked them to do this for us and it never got done. So now we're gonna try to figure out why.
Were you disappointed in the way that DCCF handled your request to block the number?
Yes.
Have you ever had a situation before where they disregarded a request from you?
No.
And I understand the point you made, sir, that you don't have official law enforcement authority over them. That's true, correct?
That is correct.
But you work with them regularly.
Yes.
And was this surprising to you?
Yes.
And is this entire issue, this entire situation where we have, at least by my count, 19 attorney-client phone calls, because I'm taking off the 0% ones here to be conservative, 19 attorney-client phone calls listened to by 12 different government agents or officers, is that unprecedented in your experience?
Yes.
No further questions.
Sheriff Lewis, is it accurate that Prairie County contracts with DCCF for all Prairie County inmates?
Yes.
Approximately how many Prairie County inmates are there in a year?
If we averaged one, I'd be amazed.
Pretty small county.
Pretty small county.
Is it accurate that you didn't have access to the IC Solutions account at Dawson County Correctional until Sterling Brown was booked in there on February 14th of 2023?
That is correct.
And is it also correct that you didn't receive any training about how that system worked? You were kind of learning on the fly?
Yes.
And you testified this morning that Agent Tucker directed you to listen to the defendant's jail calls. Is that correct?
Yes.
Is it also correct that he never told you to listen to attorney calls for this defendant?
That is correct.
And is it also correct that you would not have done so even had you been asked to do that?
I would not have.
Because this is something you take seriously.
Very serious.
And is it accurate that once you got access to that IC Solutions service or database with DCCF, that you had one account for your office?
Yes.
And folks who listened to the calls before the court in this issue today are yourself and your deputy, Jason Gray Eagle, right?
That is correct.
And when you got this access, was it your understanding that attorney-client calls wouldn't be recorded?
That was my understanding, yes.
And so as you're clicking through these recorded calls, you weren't anticipating that there would be an attorney call, right?
Correct.
Do you recall approximately how many calls Mr. Brown made during his time as an inmate at DCCF?
Just a touch over 2,200.
Did you Google all those phone numbers?
No,
Did you listen to all of those calls?
no.
What were you listening for?
Information.
And you testified that you listened to part of a call on February 15th of 2023 that you determined during the call was in fact with an attorney, right?
Yes,
And you've testified today that you have no recollection of the contents of that call other than hearing that it was an attorney and turning it off.
correct.
And then you notified right away the county attorney, right?
Yes,
In our office
yes,
and Dawson County Correctional, right?
yes,
And you also made a note in IC Solutions.
yes.
And you don't have the ability to block numbers in IC Solutions, do you?
No.
So you pretty much did everything you could.
Yes, ma'am.
Consul, I have to slow you down.
I'm sorry. And so you also told your team, don't listen to calls at this number, right?
Yes,
And you talked this morning about another instance where Deputy Gray Eagle listened to a call that ended up being between the defendant and one of his attorneys, right?
yes,
And if I understand correctly, that was a new phone number, right?
yes,
And we now know that was Mr. Jasper's cell phone number, right?
yes.
And when were you notified as Deputy Gray Eagle's supervisor that that had occurred?
Immediately.
And what steps did you take to correct that issue?
We made note of that number. We also contacted DCCF to report that number as well. And then I also ran across the hall and let County Attorney Rice know.
Did you receive any information without telling us what it may have been from Deputy Gray Eagle about the substance of that call?
No,
When you did your interview with Agent Tucker about this issue on November 24th of 2023, do you recall showing him any of the calls in the system?
I believe I had an example of what the call would look like, yes.
And you were asked about, and we admitted, Defense Exhibit U, which is a copy of the transcript of your interview with Agent Tucker, correct?
Yes,
Do you have that in front of you?
I do.
May I refer you, please, to pages 9 and 10 of Defense Exhibit U, your interview transcript from November 24th of 2023?
Okay,
Would you agree that during that interview with Agent Tucker, you clicked on a 0 call from March 4th of 2023?
yes,
And to be clear, a 0 call is a call that is dialed but doesn't connect with the intended recipient, right?
correct.
And you clicked on that during this interview to show Agent Tucker what that looked like.
Yes,
And there was no information in that call because the call never happened, right?
correct.
And I guess better verbiage is it didn't go through.
Correct.
So Sheriff Lewis, as we sit here today, to the best of your knowledge, if you, your undersheriff, or any of your deputies or reserves obtained any information about this case as a result of listening to recorded calls between the defendant and his attorneys or their staff,
No information.
and to the best of your knowledge, have you, your undersheriff, or any of your deputies or reserves been given any information from anyone that was obtained as a result of anyone having listened to any of these calls?
No,
And lastly, Sheriff Lewis, are you aware of anyone from Dawson County Correctional, from Adult Probation and Parole, from the DCI Drug Task Force, or from the Dawson County Sheriff's Office sharing any information they may have heard in any of these calls with yourself or any of your team?
No.
Thank you so much for your time. I appreciate it.
Yes, ma'am.
Redirect?
Thank you, Your Honor. You did, Sheriff. What was it your job to look at prejudice to the defendant, to try and sift out, sort out, figure out how the listening of 19 phone calls, according to Tucker's analysis, by 12 different people, how that may have affected this investigation?
I don't believe that was what my job was at that point.
And that's not addressed in your report then?
No.
And do you have any training, understanding of how a person would ever do that?
No.
Do you agree with me that when you're doing an investigation into a criminal case, it's a fluid situation?
Yes.
Do you agree that you get information, particularly in large cases, from multiple sources?
Yes.
Sometimes sources from other sources, hearsay sources, and what you do is sift it out. Look for the info, talk to the people, right?
Look for the facts.
Yeah. And so it's hard to go back in any case, much less a large case, and precisely identify where every piece of information came from. Would you agree with me?
I would agree.
And would you say that is particularly true in a case involving an alleged homicide and 2 different defendants?
I agree.
Now, when we looked at Tucker's report, and based on your own analysis, you know that DCI Drug Task Force Agent Miles Beisch, do you know that agent?
Miles Beisch.
Beisch, okay.
Yes, sir.
So Miles Beisch works for DCI, correct?
Correct.
Have you worked with him before?
I have, but not through DCI.
And the agency responsible for investigating the crime alleged to have occurred by Sterling Brown is DCI, correct?
Correct.
You were asked about a 0% call. If there's been testimony about what that means and whether you can rely on 0% or on any percent when it comes to this IC solution system, do you have any expertise in that particular area?
No, sir.
If we look at the data, and if we look at page 36 of Tucker's report, which is exhibit 16.
And I'm sorry, you said page 16?
Sorry, 36.
Oh,
my
page
apologies.
36. Yeah. Got it.
And this at the kind of the bottom half of that page is where it's talking about the February 15th, 2023 call, correct?
Yes.
And it says there, the second from the bottom, Prairie County listened 79% play February 15th, 2023.
Yes.
So, and that's just confirming, first of all, you listened to that call on February 15th, that day.
Yes.
And then it says at 15:34. Do you know what that means?
That is the time that I clicked on that call to start listening to it.
If the information we received from IC Solutions, which has been identified as Exhibit N, shows that call listened to at 7:49 p.m., do you have any explanation for the discrepancy between 15:34 here and 7:49 p.m. listed on Exhibit N?
No.
What you do know, though, is you immediately called DCCF,
Yes.
along with the other law enforcement agencies involved.
Yes.
And in fact, I mean, is it fair to say you called everyone you could think of involved in this case to say, block the number?
Yes.
When you spoke with DCCF, did they tell you whether or not they had received calls from Mr. Jasper's office earlier that day?
They did not let me know that.
Did they tell you whether or not DCCF itself had placed a call to Mr. Jasper's office that day?
No, they did not tell me that.
Did they tell you whether or not his number had already been registered, or at least should have been?
No.
And if we go back to Exhibit O, this is this spreadsheet of the calls. I want to talk to you briefly about this call that Deputy Gray Eagle listened to. And so if we look at the first column, or excuse me, the first row, and then the column of a call on August 1st, 2023, and you see the phone number there is listed as 327-4100, but I think we've cleared up that that is a different number. It's a cell phone number.
Yes.
And is that your understanding, sir?
That is my understanding, yes.
And so the Gray Eagle call, where he listened to an attorney-client phone call and then stopped, would have been on August 1st, 2023.
Yes.
And when that happened, he immediately told you, and then you went through the same exercise you've done before, which is calling in the cavalry, right?
Yes, sir.
Telling everybody you could, prosecution team and DCCF, block the number.
Yes.
Can you explain then why, if you look on August 4th, 2023, you see DCCF Captain Desiree Riley listening to a call from that very number?
I see that.
Can you explain why that happened?
I cannot.
But they should have known not to.
Yes.
No further questions. Thank you, Your Honor.
Anything that's happening to this?
Yeah, that's plenty first for me, right?
You and me both. All right. Do you swear the information you're about to provide is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Have a seat, Mr. Jasper. And although we all know who you are, why don't we state self first and last for the record?
Sure. Lance Jasper, LANCE-JASPER.
All right, Ms. Lyons, you may proceed. And again, as long as everyone speaks at a reasonable clip, I think the hope is that we go till about 12:40 and then we'll recess for lunch.
Good morning, Mr. Jasper. We know each other and work together, is that correct?
It is.
And before we get started, I'd just like to confirm with you that I will not ask you to disclose attorney-client conversations with our client Sterling Brown, and you will agree not to disclose them.
Can we try? Yes, that's our plan.
What's your current occupation?
I am a partner in Reed Bell and Jasper in Missoula, Montana, 202 West Spruce.
How long have you been practicing law?
Little over 25 years.
And how long have you been practicing criminal defense?
Little over 25 years.
And can you estimate how many criminal cases you have defended?
Thousands.
Have you handled felony cases, including deliberate homicide cases?
I have. I've tried homicide cases. I've tried basically every criminal case probably has to be tried.
And do you and I both represent the defendant in this matter, Sterling Brown?
Yes, we do, along with the Boone Carlford firm.
Is there anyone who used to represent Sterling who no longer represents him?
Yes, Jordan Kilby used to be with our firm. She no longer is, but she was a big part of the representation with myself for approximately a year of it.
Okay. When were you retained to represent Sterling?
Approximately February 13th, 2023, in that area.
When was the earliest you remember communicating with the Attorney General's office about your representation of him?
February 14th, 2023.
Can you describe the first communication you remember with them?
Sure, it would have been with, at that point in time, Mike G. He was the special prosecutor that was handling the prosecution person I'd worked with before, known well, respected him greatly, had a lot of respect for the AG's prosecutorial service at that time. So, yeah, it was very good.
Did you call him first or email him, or how did that happen? Do you remember?
Yeah, usually what happens in that, once I know that the AG's been appointed to help in smaller counties, is I'll reach out and just find out who's on the case. Here, I learned that it was Mike at the time and had his cell phone number, and so we got a hold of him. And then we just talked back and forth. It's pretty standard that way.
Give me a second here. I'm gonna hand you where are we on now? V, exhibit V. Victor. As in Victor. Is this a stipulated one? We stipulated to the admission of exhibit V, but I would move for its admission.
V is admitted without objection.
What is this, Lance?
This would be an email in response to our conversations where Mr. G was getting the pleadings that were going to be used in the arraignment, so that I would have an understanding of the charges and information I could go over with my client. As he was going to be in custody, he was being transported on the 14th, so he'd be in Dawson County Correctional Facility. So this is just typical of collegial exchange between attorneys to get information between each other.
Okay, and just for the record, this occurred on February 14th of 2023.
Yeah, this is when the AG's office knew that I was going to be involved in the case. Mm-hmm.
I'm gonna hand you what we should mark as exhibit W. This is not stipulated. Do you recognize exhibit W?
I do.
How do you recognize it?
I worked to obtain the phone records for my office to try to determine the calls that were made to and from my office to the Dawson County Correctional Facility that are different numbers than the IC Solutions phone numbers that are, we're talking about recorded numbers. So this is like talking with staff. When you're trying to arrange visitation, like to set up so they know you are the attorney of record, so that they are, or if I'm bringing someone with me that isn't an attorney, you have to do a background check oftentimes on it. So I wanted to be able to see if it was even possible. And it was my way of trying to see if there was a way to show the conversations that took place not only between us with the detention center, but then also the detention center with us that weren't on the IC Solutions, because these are calls that weren't recorded but took place because you're talking with actually the staff or the management.
Okay, and so does this appear to be a true and accurate representation of the records that you obtained related to the incoming and outgoing calls with our office?
Yes.
I move for the admission of Exhibit W.
Would I please, Your Honor?
Yes.
Who is Kevin Wickham? Kevin is spelled K-A-V-I-N, Wickham, W-I-C-K-H-A-M.
He is the individual I was speaking with from our computers, the phone system that we use at our office. He's the systems administrator that was working on Sunday and helped me get this as we were on the line and did the special summary because I didn't want to have the...
I just asked you who that
Oh.
was. And Granite Technology Solutions is a company that oversees your phone line?
Correct.
And you could have got these records at any time, right? There's nothing that prohibits you from getting them prior to Friday, June 13, 2025, right?
Nothing would have, if I would have thought of it, yeah. I didn't think of it.
And these numbers are generated by the folks, this document comes from Granite Technology Solutions, is that right?
It is.
And they could speak to what these means, especially since you talked about a discrepancy, right?
A what?
A discrepancy, you said there's a discrepancy?
No discrepancy.
I thought you said there was a discrepancy between these calls and what showed up at the detention center.
No discrepancy. Two different systems.
Okay. No, I'm going to object. First of all, there's no foundation for these documents. Mr. Wickham is not here to talk about it. He's subject to cross-examination. And what's even more problematic, Your Honor, is we just got these on Friday. And so not only do I not have a chance to call Mr. Wickham on the weekends, I don't believe, but you know, we just got this on Friday and I would ask that it be excluded. At some point here, Your Honor, we have to have some fairness for the state here. And again, I would move to exclude on those grounds.
And the email is actually dated Sunday, June 15th.
Oh, excuse me.
Did you get them on Friday or did you get them Sunday or Monday?
I apologize. It was actually Sunday this patent just indicated. I apologize, Your Honor.
Yeah.
No, but your attorney.
Judge, these are records of a regularly conducted activity from our office. Mr. Jasper is a shareholder at the firm. These are records that are available to him and he obtained them.
So, I agree, the production is just too late. The state has not had an opportunity to follow anybody about what this chart even means or to be able to do any sort of individual inquiry. If the point of the chart is that staff members from a law firm communicated repeatedly with administrative officials at the facility at DCCF for various administrative tasks, like scheduling interviews, scheduling the contact room, communicating about issues regarding their client, that's understood, that would have occurred. But I'm going to deny admission of Exhibit W on the grounds of late production and unfair surprise to the state.
Understood, Judge. Once you, Mr. Jasper, once you enter an appearance in a case, is there anything else you typically do at the inception of your representation?
Yeah, certainly. I reach out to the prosecutor and discuss, you know, what is the case about. I'm going to talk about that. In this case, it was unique in several factors. One was that it was in Prairie County, county I haven't practiced in, and didn't know exactly where my client would be housed. And so I needed to know what detention center that would be at. So I worked with Mike to figure that portion out. I would want also to, you know, just figure out who's on the case on it, and being that this was the AG's office on it, they have a, you know, you take a lot for granted usually when the AG's office is involved. Frankly, you know, usually when they say something's going to happen, things happen on it in this situation, because we had initial appearance coming up really quickly on it. And so when I file my initial appearance,
This is just a narrative, it's not responsive to the question. I have no way to make a lot of objections as we go through the testimony, so I'm gonna just object to the narrative.
Let's try to shorten it.
I'm happy to break it down, Judge, and I intended to do so. Along with your notice of representation and your notice of appearance with the court, did you request discovery in the case?
yes, I would send out standard discovery, which would request basically everything, including Brady information.
Did you talk to Sterling on that day?
On the 15th, I would have spoke to Sterling.
Is there an X? Handing the witness and the court exhibit X. Do you recognize exhibit X?
I do.
How do you recognize it?
This is transcripts of the calls that were between myself and my client that took place that were recorded by the Dawson County Detention Center.
Do these appear to be true and accurate redacted transcripts of calls with your client?
Yes.
Move for the admission of Exhibit X into evidence.
Member Dyer, Your Honor. Exhibit X represents how many calls?
It represents one call to the 541-4100, which is my office, and then the rest are cell phone calls, which represent. $18.
And when were these provided to us?
You don't get attorney.
No, when was this
Just answer
exhibit
the
provided?
question, Mr.
I'm
Jasper.
sorry.
Okay, just answer the question.
Right now.
Right now? And what, the transcript of these calls, do these exhibits control, have a complete transcript of the entirety of the call?
I'm sorry, what?
You said there's a transcript of the call, right?
These are transcripts of the call.
Yeah, it's not a hard question, Mr. Jasper. Is it the entirety of the call, the transcripts?
No.
And what, as you go through all of these, what portion did you decide to provide the court with the transcript?
The portion that shows that I announced myself as an attorney at the very beginning of the call.
So every one of these transcripts is the first moments of the call?
What do you mean by the first
So
one?
maybe I can, let me see if I can clarify this for myself. The redacted phone calls that you present in Exhibit X, are these complete transcripts? If you removed all the black boxes, are the calls in Exhibit X complete transcripts of every call that is referenced by date in this exhibit? If we were to remove the blackout portion, are these complete transcripts of those calls?
that to be true, yes.
Okay, so if they are blacked out and the only portions of the calls that have not been redacted is the introductory language either that exists on the recording through IC Solutions or your identification of yourself as the caller, is that correct?
Correct.
Okay.
Just a couple more questions for
Yes.
clarity, Your Honor. Just wanted to clarify a couple things. When these were developed, as you look through these exhibits, the portion that is transcribed, the portion that we can see that is transcribed, is that always the initial conversation for every call? Or are some of these portions that are transcribed deeper into the call?
I don't understand. The introduction of myself?
So if you look through these, you have them in front of you.
Yeah.
The portion that is transcribed, that your office decided to transcribe, is that the first part of the conversation? It's just a basic question.
This is the introduction.
I haven't had a chance to look at these, so I'm asking you a question. The portion that you transcribe, is it always the introductory, the first thing that's said on each of these calls?
Yes, I think this is on these are the first part of the calls, yes.
Okay, so it's not a situation where you transcribe something in the middle of the call and give that to the court. This is always the initial portion of the call.
Yeah.
Okay. No objection, Your Honor.
Okay. We did have a colloquy about your client's consent to production of these portions of the calls, the attorney-client calls, and that he had had time to speak with counsel about that and did not object. Mr. Brown, is that still your position?
Yes, Your Honor.
Your Honor, may I have a water?
Sure. All right, with that discussion and with the foundation, I will admit Exhibit X.
Mr. Jasper, looking at the first call from February 15th of 2023 at 11:31.
Yes.
Do you recognize this to be the call that Sheriff Lewis was referencing earlier today?
I do.
That he listened to for 5 minutes, over 5 minutes?
I do.
And moving through these other calls, what was your practice when the call began with your client?
With regards to calls that came into 541-4100, that is our law office. It's the standard practice of the person that answers our phone to say, "This is Reed Bell and Jasper, law office, may I help you?" on it. So every time anyone calls our office, that's a standard. With regards to this client calls my cell phone and I'm prompted that I'm getting a call from a detention center, I try to always say at the beginning, "This is Lance Jasper, I'm the attorney for this client. Please do not record it or listen to this." Something about it.
Okay. What is your purpose for saying that at the beginning of the call?
Is to try to make sure it's not recorded or listened to.
Do you remember the first day that your office contacted the Dawson County Correctional Facility?
I do.
And what was the purpose of that contact with the facility?
So when you are working with a new facility that you haven't been to before, to prevent any problems in your visitation or anything going haywire, what you want to do ahead of time is provide them with any and all information they might need. So you do that.
Okay. Mark, this is Exhibit Y. Do we stipulate in this one, Megan? Visit.
No objection.
Why is it objection?
Do you remember this email with Mike G?
I do.
Why is this significant to you?
Because at this point in time, Mike and I are working together to try to get everything handled. This is a major case, and so he's copying me on this, along with Mr. Kaczynski, to show that we're just working together to get Dawson County Detention Center in the loop, making sure that we can have our clients appear in person on it. And, you know, Mike, I can't make the detention center do anything, but the AG's office, if they say something, it gets done. And so Mike's just doing what he normally does. It's just collegial. And so he's copying this to show, and he's also copying Felicia or Haley as well, the co-defendant's counsel as well, because we're going to be appearing shortly. And so this is just, I don't know who Brett is, but to me, it's someone that deals with the detention. So, you know, it's just going like normal.
Okay. And had you ever been to the Dawson County Correctional Facility before?
I hadn't prior to this.
Did you have our office call the correctional facility as well?
I did. On the 15th, we spent significant amount of time because not only we hadn't been there, but I was bringing my investigator, Micah Allard, with us, and so we had to provide them the information for them to do whatever they needed for him on it. So they had communicated back and forth, but whatever, it got accomplished.
Okay. Did you receive confirmation that the Dawson County Correctional Facility approved the visit and was planning on you coming?
Yes.
When did you receive that confirmation?
Was it 16th maybe? On February 16th? We're good to go.
We have heard, we've heard some testimony about a form to fill out and a private line to speak with the client on a telephone line. Did anyone at the Dawson County Correctional Facility or the AG's office tell you about these or reference them in any way at that time?
Absolutely not, just the opposite.
Was there anything else that indicated to you that this was all set up and you were scheduled to have a normal meeting with Sterling at the jail to prepare for his initial appearance?
No, it was perfect. I mean, it happened fine. We didn't have to wait. They had a room ready for us. We didn't ask for any additional information. We signed in, provided the information we needed. We weren't asked anything special. It was set up just like it would be in any other normal situation.
Okay.
Jasper, did you physically go into the facility then on that day when you arranged it in February?
Yes,
So you were physically present with your investigator at DCCF in February 2023
yes,
and signed into the administrative law?
yes.
I'm gonna hand you Exhibit Z. I think this is a stipulated, but I want to make sure.
No objection, Your Honor.
Exhibit Z, submitted without objection.
We were referencing a Brett earlier, and does this exhibit refresh your recollection on who Brett was, first of all?
Yeah, it does.
Dawson County Attorney?
Correct.
Okay, and this email to Mike G with Dan Gazinski, Haley Forcella, yourself, and Jordan Kilby copied. Why is this important to you?
It just shows that there's a professional respect that's going on in collegial. We're working together, and this is how it normally works between myself and the AG's office with Mike Gee, anyways, on it. And we work together, coordinating, and normally all of the court coordination with an inmate is not generally done with the detention center. It'll be with the help of the prosecutor. And in something like this, it was a major case on it. I've never worked in Dawson County before on it because it was a Prairie County actual case, but it was being done in Dawson County. Didn't know the normal people to deal with on it. I relied a great deal on Mike's connections on it, and he was happy to help.
Okay, so based on this email, you believe that Mike G had the ability to make sure that the facility knew this was happening and knew who you were. Is that accurate?
Yeah, this was the part with getting my client to the initial appearance. With regards to the registering at the detention center, we had that covered. I mean, that's done.
Okay. So you met with Sterling on February 21st as well? Is that accurate?
Yes, we're multiple days there.
Do you want to go to
Double A.
AA? Okay. I'm gonna hand you double A. I don't remember our status of this.
No objection, Your Honor.
No objection, AA.
You recognize this, Lance? What is this?
This is the discovery we received from the prosecution. I'd requested the visitor log, which are, when you walk into the Dawson Center, Correction Center, this sits on the top of the desk where a detention officer sits, and you would sign in with the visitor. You tell who you're visiting and the reason for it, and it tracks when you're signing, basically sign-in sheet. And so I requested this sign-in sheet for the time that Mr. Brown was in custody, and then asked that it also extend after that for a period of time while the investigation was taking place into the attorney-client violations. And this is what we got in return for it.
Okay, and so does this reflect the time that Sterling Brown was actually in custody?
I don't know on it. There's some of it is blacked out, and it appears there's some books missing, but it doesn't show any of the visits that I had with my client. It doesn't show the times, the people that were with me, or it doesn't also show the expert that I had go in as well to meet with my client.
But, so nonetheless, does this look like the logbook that was sitting there when you would go enter the facility?
It is.
And did you in fact fill out the logbook, and did Micah fill out the logbook?
Every time that we went to the detention center on it, we would sign our name to it, and then whoever was with me would be there. First visit, Mike Allard was with me. Other times, like Jordan went to a visit, and then I went, and I had 2 interns with me, then I've had experts go on my behalf. I've had another time where I've had Scott Kinney with me. It would reflect each time I go who is with me and how long essentially we were there on multiple occasions.
I was gonna object. We stipulated the exhibit just to be cooperative, but this has nothing to do with the issues. The state would like not to depend on some evidence of staff need as well. The court has indicated they have 2 solid days, and this has no relevance to it whatsoever, Your Honor.
I think it's corroborative of the fact that he was physically in the facility sitting with the client. There was, I'm assuming that the point is that there were numerous opportunities for the facility to identify who was counsel for Mr. Brown. Is that fair?
Correct, Judge, and the reason for the visit and the inmate's name and the visitor's name and signature.
And because of the way that the exhibit AA was produced, we have no idea, as all of the names have been blocked out, that Mr. Jasper's name may appear somewhere under that big black box.
Correct.
Okay, all right, I think I get the point and we can move forward.
Sounds good, thank you. When you arrived at the facility for the first time, did you interact with detention center staff?
I did,
Do you know how many staff?
3 or 4.
Did they appear to know and recognize who you were and that you were an attorney?
They were expecting our visit, and so they knew that I represented Sterling Brown.
Okay. And when you and Micah met with Sterling, where did you meet?
You go through one door, and then off to your right, there is a room, which what I would call is where they do video court, and that's where it's all, basically all windows, where it's right next to what I call the bullpen, where they can oversee all the cells.
Okay. Did you have a concern at that time at all that you were being recorded or monitored?
No, not really, no.
How long did you meet with Sterling?
The first time would have been several hours.
What do you normally do in your practice in the first meeting?
Objection relevancy, Your Honor.
I go,
Hold on.
sorry.
But I don't want to.
Yeah.
The question here is, getting at, should the facility have known, did they have information that they should have blocked the numbers, and yet they didn't? So anything that goes into what we do at visits, how we interact with the client, is getting too close to the issue of attorney-client. So let's just.
Understood, Your Honor. Did you then appear in court with Sterling for his initial appearance?
Yes, I did.
Who was there on behalf of the state?
At the initial appearance, Mike, I believe, was there from the state.
And Dan Rice, possibly.
Oh, Dan Rice, yes. Oh,
Was Jake's initial appearance around the same time?
it was.
Was Jake also in the detention center?
He was.
When you needed Sterling to send items to our office, is there anything that you do to ensure that somebody looking at the items knows that it is directed to you and that it is attorney-client correspondence?
Yeah, for us, it's standard to make sure to do an extra thing is we usually send pre-stamped addressed envelopes to our client that make it clear that it's legal mail on it, and knowing that we've registered, it was done, in fact, cleared with the detention center, so they knew that that was happening on it, because previously I'd given my client, that's the way we had to communicate because of the distance between Glendive and Missoula, so he needed to have these envelopes on it, and it's critical.
Okay, and my question was, I wanted that information before the court because those envelopes have been referenced earlier, but in terms of the actual things that the client may be writing or sending to you, do you instruct them to do anything on those pages to ensure that somebody looking at them would know that it is attorney-client legal correspondence?
Yeah, 100%. They put "to my attorney Lance Jasper" on the top of it and on the back side of the paper so that it stands out prominently, because most detention centers do just as previously described. They want to see if there's contraband, and they want to see if it's truly legal mail. So you put on the top of each page that "to my attorney," and on the back side of it, so that when you turn it around, each page will have that "to my attorney" and Lance Jasper.
Can I hand you exhibit that has to be marked exhibit B? B as in boy. Do you recognize this document?
I do.
How do you recognize it?
It is a letter from my client, Sterling Brown.
And for the record, is it completely redacted letter other than the first headline on the front page?
Yes, it is it represents the letter, the way, the redacted letter is subject to the ones that were opened by the detention center on it. These are accurate, showing exactly how they were with regards to the "to my attorney Lance Jasper" on it, front and back, with everything else redacted out of it. This is just one portion of the letter. It doesn't constitute the entire letter. This is a representation of what we instruct our clients to do in mailing tools.
Okay, move to admit exhibit B into evidence.
I think this may be stipulated. Let's have a question for pedagogy purposes, Your Honor.
Okay.
So you did not include the whole letter, right?
No.
And how many pages is the whole letter?
Oh gosh, over 60.
And this is all in one envelope?
Yes. There's two envelopes, take that out, 2 envelopes with over 60 pages. So it breaks down about 30 pages, 35 pages in each one.
And at least 35 pages, was it part of the envelopes that were opened?
Yes.
And then it says "to my attorney Lance Jasper." Without going into any other representations or arguments about this document, where does it say Sterling Brown's name in these 60 pages? Well, Your Honor, there's...
Did it exist? Was there a signature anywhere? Was there, the facility's defense has been that they couldn't figure out who the inmate was in order to verify that you were counsel. So if you can recall, did Mr. Brown's signature, inmate number, did anything identifying him exist in the correspondence?
No, just that my name was in the very beginning.
And then the envelope we're talking about, that was an exhibit at the very beginning, that had your name and address as not only the send, the to, but also the from.
Yes.
Okay.
No objection.
Anything else?
No objection. Thank you.
Okay. Exhibit BB will be amended.
This letter has been talked about in testimony during this hearing. Is that accurate?
It is.
Without talking about what is in the letter, how would you characterize the nature of this letter?
No, we're not going there. Doesn't matter. It's an attorney-client letter. That's all I need to know.
Understood. Thank you. Mr. Jasper, when did you first become aware of attorney-client privilege invasions?
Prior to the initial appearance, we got a call from Mike. He indicating that the sheriff had listened to a few seconds of a call. That was the first time on it, and then I met with the sheriff at the initial appearance and talked to him in person.
Do you know which call that was?
I can't remember off the top of my head, but it was prior to around the initial appearance time. Right? It was referencing the 215 call on it, but when I was actually notified, I think it was, seems like, I can't remember the exact time, but we were notified right away, and that took a lot of,
Okay. What was your response to them having notified you about it?
just what I would expect to happen. I mean, I've never had it happen before, but dealing with Mikey, that's exactly what I would expect out of Mike, and that's Sheriff Frank.
So based on the prompt notification and what Sheriff Lewis testified today, assurance that it would be handled, did you trust that that would be the case?
Absolutely.
Was there anything that happened after that that made you think that it was actually not resolved?
Well, on March 7th, 8th, 9th, somewhere in there, we were notified that the detention center had opened legal mail of Sterling Brown.
Okay. And I believe that initial email has already been admitted into evidence. I'm gonna hand you what we should mark as Exhibit C. C is in cat. This one that we agreed to.
No objection, Your Honor.
CC is limited.
Do you remember this email exchange?
I do.
Anything about the first part of it that is significant to you?
This is starting on going from the back, obviously, because that was the first email, but this is working again with Mike Gee, putting on notice of another violation of the attorney-client privilege. And this is where we are looking at alternatives to remove Sterling to a different facility to basically take away the chance of this happening again on it, and get Sterling potentially closer so we could work with him. It wasn't our intention to have to take Sterling out of custody on it. So, we're concerned, we're looking for options to stop the violations on it. In addition to that,
So in this email correspondence, did Mike acknowledge the jail call / mail issue?
Yes, he did on it. With regards to that, he replied to us on March 15th on the paragraph that starts, as for the jail call and mail issue side on it. Confirms that the Perry County Sheriff has reached out to the Dawson County to remedy that. And it says, apparently it requires you to call again to register. And so, again, it's already been done, but we do it again.
And So on March 16th, did Jordan Kilby indicate that she was going to in fact call again to register the number?
Objection, Your Honor. I know the rules of evidence don't establish it, but this is an important point here. It's an important evidentiary point where the person that actually made the call was subpoenaed, was prepared to come as far as I know, and she's not here. And I think for this line of questioning, it's useful for the court to actually have the person that made this alleged call testify in person rather than on hearsay.
Jordan Kilby.
Jordan Kilby is in the was in the emergency room yesterday, apparently. I believe that it's possible I could Zoom her in to testify if the court deems that necessary, but I believe that they stipulated to the admission of this exhibit, and I don't really need to ask about what she said.
Jasper, as far as you knew, based on the email communication, CC that you were copied on, you believe that your associate, I'm sorry,
Jordan Kilby.
female or male,
A female.
whether she had in fact communicated with the facility to register your numbers.
She tried that night, the phone got cut off, and then we took care of it the next morning.
Okay, and when you say took care of it the next morning, tell me how you knew or became aware that it had been taken care of.
Because my legal assistant Tammy and I did it together to get it done.
When you say did it together, tell me what you did.
So, because on top of the fact that this had happened, Tammy and I worked together 25 years, but because of the fact we're right next together on it, and so I wanted to basically see the fact that we were getting it done because it was important to get this as a second time on it. And it seems so bizarre that, to me, I've never had an experience like that.
I know, but we're gonna move
Okay,
on. Tell me what you
but
did.
so anyways, just to document it so that I was there to make sure it was done, Pam and I just did it, registered it. It took 30 seconds to give them our number on it. And again, the cell phones for Jordan and I and our law firm, the 541-4100.
That's by calling the number that is referenced in Mr. Yee's email on page 2.
Yes,
771642.
yes, we registered with them.
Okay,
The original one.
all right. I don't want to drag this Kilby out.
At this time, did anybody from the facility reference a form that needed to be filled out by our office
No,
or by Sterling?
no.
Prior to the opening of the legal mail, are you aware of how many calls were listened to?
No.
Do you have reason to believe the call listens and the letter are connected?
Excuse me, sorry.
Do you have any reason to believe that the calls that were listened to and the letter are connected?
Yes.
So at this point, in light of the previously listened to call, the mail opening, and the situation with that, with those two scenarios, what's going through your mind?
Objection relevant to Your Honor.
I'll allow it, go ahead and answer.
Just nothing really at this point in time, because I'm told that it's just been opened and nothing read, and I'm dealing with Mike E on it. So I'm trying to look for solutions, and we're looking at trying to move him from this detention center to another one. And I mean, I'm dealing with the AG at this point in time. It's not like I'm dealing with, someone else. This is supposed to be the people that do, I can trust on it. They're gonna do what's right. And Mike is telling me that usually when the AG tells someone to do something, they do it. And so at this point in time, I don't know how bad it is. I'm just trying to defend my client. and find a way that I can securely communicate with my client. And Mike, he's a great attorney. He's ethical, honest, and when he says he's got it handled, I'm talking to him, I believe him.
Okay. And so after the mail opening, did you have another visit with Sterling at the center?
Yeah, I had several visits. Yeah.
Okay. If I told you you had a visit April 21st, would that sound accurate to you?
It would.
Were there many other calls with Sterling between, during that whole time?
Yes, countless.
And then, did you meet with him in July?
I did.
What was the next big event in the case that was to occur in the court case after that meeting?
That was the co-defendant's trial.
And between the co-defendant's trial and the mail opening, were there many calls with Sterling?
Yes.
And do you now know that many of those calls were listened to?
I now know that.
At the time, did you know that?
No, I wouldn't. No, I had no idea.
Did you attend Jake's trial?
Yes, I did.
Was there anything in Jake's trial, any testimony or evidence in Jake's trial that you believe was connected to any of the calls or correspondence with your client?
Yes.
So at this point, what did you believe you needed to do next in response to the violations?
Needed to get Sterling figure out how to get him out of detention and be able to work with him. It was no longer to be. And so we continued to try to get him transferred and then started working on it to get him released on bail.
Okay, and so did you decide to bring this issue up at a bond hearing?
Yes,
Did you meet with Sterling to prepare for this hearing?
I did.
Was that meeting at the facility?
Yes.
During that meeting, was it in the same room you referenced earlier?
Yes.
Did anything concerning occur during that meeting?
Yes.
What was that?
It became apparent that we were being recorded and it was being, our meeting was being watched.
What did you do?
Immediately unplugged the device, which was used for video record. It appeared to be the TV was off, but it was clearly broadcasting. On it, there was a detention officer outside, notified him that we had unplugged it and to stop watching us on it.
Okay. As the situation developed, did you start changing your introductory message on the calls in any way?
Yeah, I mean, I guess I got more flippant with them I continued it. I mean, I didn't change my standard of saying I'm an attorney or anything like that, but I said maybe for the 100th time, please stop doing this.
Okay. When you brought up the issue of the privilege violations at the bond hearing, what happened?
The AG's office said they would do there would be an investigation.
And did Sterling bond out ultimately?
Yes.
I'll hand hand you what we should mark as exhibit D. D is in dog. DD.
Well, we have no objection to DD being admitted.
So this email appears to be from Agent Tucker, is that correct?
Yes,
Indicating that he is going to be doing the investigation.
yes.
Why, what was your response to finding out that Agent Tucker would be doing the investigation?
You know, at first, it's just, this is unprecedented. Never had something like this happen on it. And I work a lot with DCI and representing officers, so I have a lot of respect for DCI and what they do, and work with them a lot in officer involved shootings. So a lot of respect for Mr. Tucker on it. Then, I would like someone with his skills to investigate it, but I become really concerned that it's just stupid to have him, in my mind, investigating this. And so I try to convince him to not do it because of a conflict of interest on it, and asked him not to do it. And I just can't understand how, as the lead investigator in a homicide, just in any way that he can do this investigation. And then I just, it was very troubling, and I didn't want to see Brad in this situation because he would be up on the stand at some point in time, and I couldn't understand how Dan Kaczynski could put this investigation into their hands. It just seemed lunacy to me.
Okay. So once the investigation started, did you nonetheless do an interview with Agent Tucker?
I did.
Did you, this one already exhibited? No? Why did you exhibit E?
Who's referencing this years?
Okay.
No objection, Your Honor.
So EE is omitted. Probably got about 10 or 15 more minutes this time.
Thank you. During this interview, did you voice your concerns with Agent Tucker doing the investigation?
Yeah, repeatedly.
Did you tell Agent Tucker the areas that you thought should be investigated?
I did.
And do you think that they were investigated?
No. Some of them.
What areas?
The attorney-client meetings.
No, I think we're talking about interview. We should probably go to the page where this should be discussed for best evidence.
I'm gonna allow him just to continue to testify via memory. If he gets stumped, we can refer back to the exhibit. Let's keep going.
Did you feel during this interview or at any other time that you could actually even speak to Agent Tucker about the attorney-client issue?
No, I thought this, frankly, the investigation they were doing was a farce.
So immediately after the interview, what happened?
I'm sorry.
I can actually help you out. And you exhibit FF.
No objection to FF?
FF is submitted without objection.
Do you recognize this, Lance?
Yes, this was an email I received from Agent Tucker. And
If you turn to the form, the third page is asking you to complete this form and email it back to Captain Riley.
that's what it's, actually, yes, he is asking me to complete a form. And then it says see below on it. And it says email back and I will get it taken care of.
Do you know what get it taken care of meant?
No, I didn't, but in my mind, I knew it meant to pad their file to say that I didn't fill out this form on it, and so I told him no.
And so at this point, on November 29th, is Sterling in jail still?
No, that's the lunacy of it.
And so, did Agent Tucker communicate a purpose?
No, there was no discussion about some retro, anything like that on it. This is exactly what it was, and then I responded to this.
So you declined to fill out the form?
Yeah, there's a response to this.
Had you seen this form at all before?
Nope, never been asked to fill a single thing out of paper.
Hand you, is it G? I think this is previously stipulated to. GG.
No objection to GG, Your Honor.
So if you turn to the third page, excuse me. Is this your response to Agent Tucker asking you to fill out the form?
Yes,
And did Agent Tucker articulate that he wanted to retroactively block the calls
no,
in response to asking you to fill out the form?
no,
If Agent Tucker had asked you about retroactively blocking calls at this point, would you have an issue with that?
yeah, I wouldn't have known what it was on it, but I would have definitely done anything to make sure that they wouldn't continue to spread like they did.
Okay. HH, is this HH? I don't remember that.
This date does not affect the HH.
There was some discussion earlier about Agent Tucker requesting trial strategy from you, or a discussion about trial strategy. Did you have anything to add to that conversation that was happening with Miss Lear?
Yeah, I mean, one is this, literally confirmed the fact that the prosecution was directing the investigation into the attorney-client violations on it. And so they're handling the investigation into the calls and mail I've been having with my client, most sensitive information possible on it. I've asked them to please have an independent investigator do the investigation. They absolutely refuse to do it. And I asked to try to look at the investigation or talk to the people involved in the investigation. They object to us doing any of that on it. And so the other events that combine with that are, there are things that took place in the trial of Jake Burdock referencing the mail, which contained the ultimate information you could have, where the prosecution team references a draft report by Mr. Tucker on it of 310, a draft report, 310 specific to information that could, in my mind, is linked to the mail on it. And that draft report could never be produced by the prosecution. And that is in the transcript of that drama.
Was that draft report a basis for amending an information in Jake's case?
It was.
And so in this email of January 2nd, 2024, you indicated you had been instructed not to have contact with Agent Tucker by Dan.
Correct.
And your response is fairly aggressive and flippant. At this point, were you frustrated?
Yes, past frustrated. I mean, I'm used to dealing with the AG's office where they're beyond reproach. They're supposed to be the best of the best to deal with. And then to have, where they're literally trying to block the uncovering of something that's unprecedented in our justice system. Yeah, I'm past frustrated at this point. Who wants to investigate themselves on it? That's why they get called in, because DCI gets called in to be the investigator of these type of things on it. And it's crazy. It's lunacy to me. Yes, I'm frustrated, and I'm at every turn, like, we're trying to move them to a different area, and it appears that, we're getting cooperation to do that. And that was all a farce on the part. It's just frustrating.
Judge, I just want to do a time check. My perception of time totally disappears when I'm doing this, so.
I also need to get an understanding of how many witnesses we all have left. We're running out of day. So why don't you ask me more questions and get an update on the number of witnesses.
I'm almost done, actually. Are we on G?
Yes.
G.
No. I.
And you. I. I don't know if we talked about this. Okay. I think, Judge, we would stipulate to this being admitted under seal.
What is the
It is Sterling Brown's inmate file from Dawson County Correctional Facility.
Okay, quick flip, it appears that sheets have personally identifying information. So what is the state's position on admission of II when whether the objection to it needs to
The state has stipulated this, so we'll honor that, I think.
Okay, so I will be admitted, but it will be sealed, given that there is personal identifying information.
Why did you request this?
Because this is the information that would be contained by the detention center, which should normally contain all of the information that would be provided to Sterling Brown and contain communications with our office. And yeah, it's their records dealing with Sterling Brown.
Did you see the form for the attorney-client privilege phone call? The form that Agent Tucker had sent to you. Did you see that form in this file?
I did, 3037.
So, when you saw this form, what did you think about that?
It confirmed my belief that the investigation was a farce. It was put in here to try to basically indicate to the court that they had a form in place that I could have signed that would have made this all just not have happened on it. However, it's clear by the email that we have from Mikey early on, just simply one, we made, not even Mikey, we registered with this detention center at the very beginning. It's obvious by the communications with Mike on that. But then additionally is they had no policy because of two things. One, we're directed to call. You heard the sheriff indicates that we were supposed to call. But this was, again, was put in there for that. But then also the reason is that if you look through this entire file, one thing that detention centers always do is they document that the individual has received policy handbooks. And so, because of all the testimony I've heard about it, I wanted to see if there was a documentation that Sterling Brown received a policy handbook, and there isn't on it. But if you go through this on it, you will see where there are several policy things that Sterling Brown did get and had to sign on it. And you'll see several things in here where Sterling Brown had to sign for over and over. There's nothing in here where he was ever asked to provide his attorney numbers or anything like that on it. And so it goes to show this idea that we were given this option of having a private number to call is a farce, not true. And it also goes to show that had they given Sterling Brown a inmate handbook on it, they would keep a record, they would have a sign. That's how every detention center I've ever worked with in Montana works. They put that as a record because they want to have that in there in case of some type of problem or disciplinary action takes place, as you were on notice, and so I have a signature that you were on notice. That's not here.
Okay. So after this, after you received this, did we do anything with respect to discovery requests and this attorney-client issue?
Yes, we made discovery requests to the prosecution team.
And we ultimately went to a hearing on October 4th with this court.
Yes, we briefed it with regards to this matter pending, and then also went on October 4th to a hearing.
And during this hearing, was there anything alarming to you that was said related to the issue of the immunity of
Well-
Jake Bergdiff?
What was alarming was the ethical attack that was taken out on me with regards to alleging that I had somehow intimidated and prevented the prosecution from being able to secure the testimony of the co-defendant on it and attempt to essentially discredit me before this court on it. And then also the representations with regards to the state and the failure of the other attorneys with the prosecution of not advising the court of the false statements that were being made after getting back to.
Okay, and so at the time of the hearing, what was your understanding with respect to whether an immunity agreement had been reached with Jake?
There couldn't be one because it was fully briefed and it was before the court to make a decision, and we were arguing about it, and the court had indicated at the hearing that there was merit to our motion and stated that she was going to take it under advisement. And so because it's fully briefed, you don't do something when it's briefed, so I couldn't be one.
Okay. Are we on G?
Yeah.
J? And no exhibits.
Are we getting close?
Yes.
No objection to JJ?
So if you turn to, I believe this discussion starts on page 62. And at the bottom of page 62, line 20, Mr. Gazinski was talking to the court about it being the state's hope that the court would grant immunity for Jake to testify under use immunity.
I see that.
And the state not objecting to giving him transactional immunity for the arson charge and the criminal endangerment charges.
I see that.
And then at the bottom of page 63, moving on to page 71, the court, or Mr. Gazinski indicated that he would share with the court and you, Mr. Jasper, in the next 6 weeks whether an immunity agreement had been reached, correct?
Yeah.
And then at the bottom of that page, he indicated that some stuff was happening with immunity issues and that he hadn't been forthcoming with the court, but he would advise the court in the near future. Do you see that?
I do.
And then was it your understanding that the court wanted him to inform the court when that had occurred?
I think the court I would take it as the court always wants you to be honest. And so I believe that. That's what I believe.
This is the last exhibit. Hey. This is the parole hearing.
Steve?
Apparently this is a video of the parole hearing, is that what it is?
Yes.
We're just receiving this now, like so many other things, Your Honor.
Were you present at the parole hearing?
I was present, but it'd be nice to have a
It's
chance.
coming in. Okay, 8 days in video.
If I let the court know the timing of when I received
I
this.
know, I'm not happy about any of it.
When did we obtain this, Mr. Jasper?
We had attempted to obtain this much, much earlier, but Mr. Kaczynski prevented us from obtaining it.
Objection, that's just an outright lie, Your
Well,
Honor.
it's admitted now and I have it, so, situation remedied.
And
And this is Mr. Burgduff's,
parole hearing,
what date was it held on?
9 September 18th of 2024,
Before I had the
before the hearing. And I'd request if the court would like to watch it. It's 10 minutes long, about 10 minutes long. So I don't know if we want to take a break or do it.
Well, in the interest, I have to break now anyway.
Yeah.
I have juvenile. Back up. 30 minutes, so I'm gonna ask counsel to be back in an hour. Obviously, do you have a question you're going to ask Mr. Jasper about the whole hearing?
Not really, I just want you to see it.
I will view it. And if I have any issues, I'll bring it to the attention of council. We should have time to do it in 2 hearings. And then what other witnesses does the defense intend to offer?
Just to Your Honor, with the court's permission, would be Justice Nelson and Randy Hood. If the court permits that, if the court does not permit that, I would make a brief offer of proof and ask for the opportunity to submit any declarations or something like that, so the court would have that available. And then that's it, Judge.
State, well, Agent Tucker is not here, just.
He is not, Your Honor, as much as we would like him. The state would intend to quickly call Deputy Gray Eagle, very quickly call Adult Probation Parole Officer Zodi, quickly call Josh Conrad from Dawson County Correctional, and then hear from Mr. Tucker.
Well, let's do our best. Let's be ready to go in